ಅವನು ತಿಂಗಳು ಚೇಂಜ್ ಮಾಡ್ಕೊಂತಾರೆ. ವಯಸ್ಸಾಗಿದೆ ಅಲ್ಲ ಅವ್ರನ್ನ, ಇದ್ಯಾಕೆ ಪದನು ಕರೆಕ್ಟ್ ಆಗಿ ಬಿಡ್ತದ. ವಯಸ್ಸು ಆಗ್ತಾನೆ ಇರುತ್ತೆ. ವಯಸ್ಸಾಗಿದೆ ಅಂತ ಇವಾಗ ಯಾರಿಗ ಆಗ್ತಾ ಇಲ್ಲ ವಯಸ್ಸು? ಅಲ್ಲ ಕರೆಕ್ಟ್ ಪದ ಹೇಳಿ. 60 ವರ್ಷ ಆಗಿದೆ ಅನ್ಬೇಕು, 65 ಆಗಿದೆ ಅನ್ಬೇಕು, 65 ಮೇಲೆ ಆಗಿದೆ. 76. ಪ್ರಜ್ವಲ್ ರೇವಣ್ಣ ವಿಚಾರದ ಬಗ್ಗೆ ಏನ್ ಹೇಳ್ತೀನಿ ನೀವು? ಫೋನ್ ಮತ್ತೆ ನಾನು ಪ್ರಜ್ವಲ್ ರೇವಣ್ಣ ತಪ್ಪು ಅಂತ ನಾನು ಹೇಳುದಿಲ್ಲ, ಅವನೇ ಸಿಗಾಕೊಂಡು ನಾವು ಫೋನ್ ಕೊಟ್ಟವ್ರು ಹೋಗಿರಿ. ನೀವು ನಿಮ್ಮ ಲಾರ್ಡ್ ಆರ್ಡರ್ ಯಾವ ಮೇಂಟೈನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ ನೀವು? ಕಿತ್ತೋದು ಹೋಮ್ ಮಿನಿಸ್ಟರ್ ಬಿಡ್ತಾರೆ. ಯಾರು ಅವಕಾಶ ಇದ್ರು ನಾವು ಅವಕಾಶ ತಗೊಂತೀವಿ. ನೀವು ಪರ್ಮಿಟ್ ಮೇಂಟೈನ್ ಮಾಡಿರಿ ಇರುವವರು ತಪ್ಪ್ಯಾರ. ಅವ್ರನ್ನ ಅಪರಾಧಿ ಅಂತಾನೆ ಅನ್ಕೊಳ್ಳೋಣ, ಅವ್ರು ಟ್ರೈ ಮಾಡ್ತಾರಲ್ಲ ಸರ್, ನನ್ ಫೋನ್ ಇಸ್ಕೊಳ್ಳೋದು. ಅಪರಾಧಿ ಅಲ್ಲ, ಅಪರಾಧಿನೇ ಮನುಷ್ಯ, ಆರೋಪಿ ಅಲ್ಲ. ಈಗ ಅಪರಾಧಿನೇ ಹೇಳಿದ್ದು, ಅಪರಾಧಿನೇ ಅವ್ರು ಟ್ರೈ ಮಾಡ್ತಾರೆ. ಏನಾದ್ರು ಫೋನ್ ಸಿಗುತ್ತಾ, ಔಟ್ಸೈಡ್ ಕಾಂಟ್ಯಾಕ್ಟ್. ಹೌದು, ಎಲ್ಲಾನು ಇರುತ್ತೆ. ನೀವು ಅಯೋಗ್ಯ, ನೀವು ಅವ್ರು ಸರಿಪಡಿ ಅಪರಾಧಿ ಅಂದ್ರೆ ಅವ್ರು ಸರಿಪಡಿಸ್ಲಿಕ್ಕೆ ಒಂದು ಜೈಲು. ನೀವು ಇನ್ನಷ್ಟು ಕುಮ್ಮಕ್ ಕೊಡ್ತಾ ಇದ್ರಿ. ಅವ್ರು ಯಾರು ಫೋನ್ ಕೊಟ್ಟಿದಾರೋ ಅವ್ರನ್ನೂ ಇತ್ತ ಸೆಲ್ಲಲ್ಲಿ ಹಾಕ್ಬೇಕು. ಜೈಲರ್ನೆಲ್ಲ ಯಾರೇ ತಪ್ಪು ಮಾಡಿರ್ಲಿಲ್ಲ, ಅದು ಆಯ್ತು ಅಂದ್ರೆ ಹಠ ಕಲಿಸ್ದಂಗೆ.
ಇದೊಂದು ಟೈಮ್ ಕೇಳ್ತೀಯಾ ವಿಸಿನಲ್ಲಿ
ಸಸ್ಪೆಂಡ್ ಮಾಡಿದ್ದಾರೆ. ಸಸ್ಪೆಂಡ್ ಮಾಡಿದ್ರೆ ಅವ್ರಿಗೆ ನೆಕ್ಸ್ಟ್ ಇನ್ನೊಂದು 6 ತಿಂಗಳು ಇಟ್ಕೊಂಡು ಕೆಲಸ ಇದ್ರೆ ಸಂಬಳ ಕೊಡ್ತಾರೆ. 6 ತಿಂಗಳು ಕೆಲಸ ಮಾಡೋದಿಲ್ಲ, ಮತ್ತೆ ಕೋರ್ಟ್ ಕೇಟಿಗೆ ಬರ್ತಾರೆ, ಸಂಬಳ ತಗೊಂಡು ಬರ್ತಾರೆ. ಇದು 23
ಅಷ್ಟೇ ಎಲ್ಲ ಅಷ್ಟೇ. ಪೇ ಫಾರ್ ಟೈಮ್, ಪೇ ಫಾರ್ ಟೈಮ್. ಸರ್, ಯಾವ್ದಾದ್ರು ಸೀನಿಯರ್ ನೀವ್ ಏನಾದ್ರು ಫೇವರಬಲ್ ಆರ್ಡರ್ ತಂದಿದ್ದೀರಾ ಅಥವಾ 1 ರೂಪಾಯಿ ಏನಾದ್ರು ಕಾಂಪ್ಲಿಮೆಂಟರಿ ಕೊಟ್ಟಿದಾರ? ಅಟ್ ಲೀಸ್ಟ್ 500 rupees as a complimentary. ಒಳ್ಳೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದೀರಾ, ತಗೊಳ್ಳಿ ಅಂತ.
ನಾ ಕೊಡಿಸ್ತಾ ಇರ್ತೀನಿ ನೋಡಿ.
ನೀವ್ ಕೇಸಸ್, ಅವ್ರ ಕೇಸಸ್, ಆಫೀಸ್ ಕೇಸ್ ಅನ್ನು ಮಾಡುವಾಗ ಕೊಡ್ಸಿದ್ದಾರೆ.
ಅವ್ರಿಗೆ ಹೇಳ್ಕೊಡಿಲ್ಲ, ಕೊಡಿ ಕೊಡ್ಸಿದ್ದಾರೆ.
ನೀವ್ ಮಾಡಿದಿರ ಅಂತ ಯಾವ್ದಾದ್ರು ಕಟ್ಟಿದಾರೆ?
ಕೊಟ್ಟಿರ್ತಾರ, ಕೊಡಿಸಿದ್ದಾರೆ. ಕೊಡಿ, ಅವ್ರ ಹೆಂಗ್ ಆಗುತ್ತೆ? ಅವ್ರ ಜಾಸ್ತಿ ಕಿತ್ಕೊಂಡ್ರೆ ಕಡಿಮೆ ಕಿತ್ಕೊಳ್ತಾರೆ.
ನಮ್ಗೆ ಬರಲ್ಲ ಅಲ್ವಾ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಡೈರೆಕ್ಟ್ ಆಗಿ, ಎಲ್ಲ ಬೇರೆ ಕಡೆ ಅಲ್ವಾ?
ಹೌದು, 2-3 ವಿಚಾರ ಅಂದ್ರೆ ಯಾರು ಬಂದೇ ಇರ್ಲಿಲ್ಲ ಕೆಲಸ ಅಂತ ಅವಳಲ್ಲಿ ಮಾತಾಡ್ತಾರೆ. ಹೇಳಿದ ಅವಳೇ ನೋಡ್ಕೊಂಡಿರೋದೇನು ಹೋಗಿ ಅಂತ ಹೇಳಿ
ಆ ತರ ಹೇಳಿದ್ರು.
ಆತರ ಅಷ್ಟೇ. ಇಷ್ಟೇ ಕೊಡಿ ಅಂತವ್ರು ಏನ್ ನನ್ಗೆ ಅದು ನಿಮಗೆ ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ ಅನ್ಕೋತೀನಿ.
ಬಂತ ಪೈಸಾ ಬಂತ
ಅಂತ
ಅಲ್ಲಿ ಬಂತ ಪಾಪ ಹುಡ್ಗನೇ ಇವತ್ ಬಂದಿರೋದು. ನಂದು ಏನಿಲ್ಲ, ಟ್ರಾವೆಲಿಂಗ್ ಎಕ್ಸ್ಪೆನ್ಸ್
ಬರೀ ಅಷ್ಟೇ ಅಂತ.
ಯಾರ
ಅಕೌಂಟೆಂಟ್ಸ್ ಮಾತ್ರ ಅಷ್ಟೇ ಅಂತ. ಯಾವ್ದು ಇಲ್ಲ, ಎಲ್ಲ ಮ್ಯಾಟರ್ ಮುಗ್ದೋಗುತ್ತೆ. ಮ್ಯಾಜಿಸ್ಟ್ರೇಟಿಂಗ್ ಬರೀ ನಾನು ಮಂತ್ಲಿ ಒಂದ್ಸಲ ಎಲ್ಲ ಕೇಳ್ಬಿಟ್ಟು ಹೋಗ್ತಾ ಇರ್ತೀನಿ.
ಅದು ಬೇಕಾಗಿಲ್ಲ, ಅದು ಯಾರಿಗಾದ್ರೂ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿ.
ಅದೇ ನನ್ನ ಕೆಲಸ, ಅದು ಮಾಡ್ತೀನಿ, ನಾನು ಮಾಡ್ತೀನಿ. ಇಲ್ಲಿ ನಿಮ್ದು ಕ್ಲಿಯರ್ ಆಗಿದೆ ಕೊಡುವರು ಹೇಳ್ತೀನಿ. ಕ್ಲಿಯರ್ ಆಗಿದೆ. ನಾನು ಹೆಸರು ಹಾಕಿದ್ದ 4 ಅಂತ ಬರ್ಬೇಕು.
ಮೊದಲು ಆಯ್ತು ನಿಮ್ದು?
ಇಲ್ಲ, ಅದು ಹಾಗೆ ಇರ್ತದೆ, ಹಾಗೆ ಇಟ್ಟಿದ್ದು.
APIM ಅಂದ್ರೆ ಏನಂತ ಇವತ್ ತನಕ ಅರ್ಥ ಆಗಿಲ್ಲ ನನಗೆ.
ಆರ್ಬಿಟ್ರೇಷನ್ ಎಂಟ್ರಿ ಮೆಜರ್. API ಆರ್ಬಿಟ್ರೇಷನ್ ಪೆಟಿಷನ್ ಎಂಟ್ರಿ ಮೆಜರ್.
ವಾಟ್ ಇಸ್ ಮೆಜರ್?
ಎಂಟ್ರಿ ಮೆಜರ್ ನ ದೊಡ್ಡ ಮೆಜರ್ ಮಾಡ್ತಾರೆ.
ವಾಟ್ ಯು ಮೀನ್ ಬೈ ಎಂಟ್ರಿ ಮೆಜರ್? ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಪದದ ಅರ್ಥ.
ಹೋಗ್ತದೆ ಇರೋದು ಸರ್. ಇಷ್ಟು ರೀಚ್ ಆಗಲ್ಲ 19 ಅಲ್ಲಿ.
ಇದು ರೀಚ್ ಆದ್ರೆ ನೋಡೋಣ ಫಸ್ಟ್.
ಓ, ಇಲ್ಲಿಂದನಾ? ಇದೆ ಜಾಸ್ತಿನೇ. 27 2700 ಒಬ್ಬರಿಗೆ 2700. ಅಲ್ಲ ಸರ್ ಪಾಟೀಲ್ ಸರ್ 1800 ಇದು ಏನೋ ಹೇಳ್ತಾರೆ. ಹಂಗಾರೆ ಅಷ್ಟೇ ಇರ್ಬೇಕು. ಲಾಸ್ಟ್ ಎಲ್ಲೂ ಆಗಿದೆ ಇದೆ ಸರ್ ಆಗಿರೋದು 18.
ಆಡಿಯೋ ಎಲ್ಲ ಮ್ಯೂಟ್ ಆಗಿ ಏನ್ ನೋಡ್ಲಿ ನನ್ಗೆ.
ಯಾರು ಕರೆಕ್ಟ್ ಅಲ್ಲ.
It came to unmute ನನಗೆ. I declined for unmuted.
36 ಇಲ್ಲ 18 ಅಂತ 17 ಅವ್ರು ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿದ್ರೆ ಇಲ್ಲ ಏನಾಗಿದೆ
ಅವ್ರ ಆಕ್ಟಿವೇಟ್ ಮಾಡಿ
8 24 8 ತಿಂಗಳದ 8 ವಾರದ ಹಾಕಿದ. ಯಾಕಂದ್ರೆ ಇಲ್ಲಿ ಲಾಸ್ಟ್ ಒಂದೇ ಸರಿ 3 ವಾರದ ಒಂದೇ ಕಡೆ ಬಂದಿರ 25/7 ಪೆಟ್ರೋಲ್ 3600 1/8/26 3600 ಒಂದೇ ಕಡೆ ನೋಡಿ ಒಂದಿದೆ 3600 ಕರೆಕ್ಟಾ 3 ಇದೆ ಇಲ್ಲಿ ಆಯ್ತಾ. ನಾಲ್ಕು ಇನ್ನೊಂದು ಹಾಕಿರ್ತದೆ 5 ಇಲ್ಲ 5 6 7 ಕರೆಕ್ಟ್ ಆಗಿ ಹಾಕ್ತೀನಿ ನಾನು ತಪ್ಪಾಕಲ್ಲ. ನೀವೇ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಬೇಕಾ? ನೀವೇ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಬೇಕು. ಇಲ್ಲ ನಾನು ಹಾಗೆ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡ್ತೀನಿ. ಕೂತ್ಕೊಂಡಿದ್ರೆ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡ್ತೀನಿ ನಾನು ಎಲ್ಲರಿಗೂ ಅವ್ರದ್ದು ರೂಪಲ್ಲ ನೋಡೋದೇ ಇಲ್ಲ. 8 ಇನ್ನು ಇಲ್ಲ ಹಾಕು ಕರೆಕ್ಟ್ 2700 ಒಬ್ಬರಿಗೆ 24 ಬಿಟ್ಟು 3 24 2400.
Concern. In response to the land council appearing to the respondent, defendant submits that this issue is no more res integra as a division bench, as a full bench of this court in WP number 40157 of 2014. In case of Mrs. Mr. Robin D. D'Souza has decided this aspect and has held up
ನಾನು ಇವಾಗ ಅದೆಲ್ಲ ಸ್ಟಾಪ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ.
corporation limits.
ಏನ್ ಒಂದು 50 ರೂಪಾಯಿ ಸರ್ ಸೈಟೇಷನ್ ಗೆ ಮಾಡಿರ್ತೀನಿ. ಅವತ್ತೋ ಒಂದಿನ ಅವ್ರು ಬರ್ತಾರೆ.
ನಾನು
ಬಿಟ್ಟೆ ನಾನು
ತಗೊಂಬ ಬರ್ಕೊಂಡೆ
ಟ್ರಾವೆಲಿಂಗ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಮಾತ್ರ ಬಂದ್ರೆ ಸಾಕಂತ ಬಿಟ್ಟೆ.
It relied on para 3F G
200 ರೂಪಾಯಿ
G A B.
ಬರ್ಕೊಂಡಾ?
This 10 page number 10.
200 ರೂಪಾಯಿ VA ಅಂತ ಹಾಕಿದ್ಯಾ?
And
ಯಾಕೆ ಸ್ಟ್ಯಾಂಪ್ 200 ರೂಪಾಯಿ ಹಾಕಿದ್ದಾರೆ?
it is submitted. The trial court has rightly considered and passed orders and no interference is called for. It's counsel for the petition on the side. There is a material on record. The only issue that for also consideration before this court is whether the court fee is liable to be paid as per the order of the court for considering it as an agricultural land or a non-agricultural land. In the light of the judgment of the division, the full bench of this court referred supra in Alfreda Winifred D'Souza's case, thus no further consideration on that aspect is required to be gone into. The trial court has rightly applied the law and rightly passed an order. And this court is not able to appreciate the submission of the land counsel of the petitioner that in Narayana's case, there has been the distinction that is sought to be drawn by the petitioner cannot be appreciated. And this court finds no reasons accordingly dismissed. Yes, next.
Till number 36.
Vika. This all these judgments. So, do you complete this? All cases in all the. Yes.
I have filed a memo for dispensation of notice to respondent.
Memo is filed seeking dispensation of notice to R3 to R11. Same dispensed with. Next.
Next, my lord said directed me to serve the summons, but that is served and my lord, The acknowledgement is
R1
filed.
and R2 are served.
Yes, my lord.
A memo is filed stating that as per the order
Memo is
passed by
not
this
filed. I
court.
only returned the summons. I'll file the memo now, my lord.
Take it. A memo is filed.
Summons is
stating
already
that
filed.
as per the order passed by this court, they have filed they have served the hand summons. And memo is also filed in that regard. Memo is taken on record in the notice to R1 and R2 is held sufficient. Interim order is there.
No, madam, there is no interim. Any date may be fixed.
Yes, this is matter on 10th of September.
Yes, I'm grateful.
Cell number
Yes, 37.
37. Cell number 37. Lingaraju KR.
Any interim order in this case?
No, no interim order.
No representation on behalf of the petitioner lists this matter in the month of September. Case
Cell number
38. Memo is filed seeking
Petitioner.
dispensation of notice to R4 to R7 dispensed with. What about the hand summons?
And someone served, my lord.
Served
Served
on
on the acknowledgement.
1 to 3,
Please.
1 to 3
1 to.
is as per the order same, and notice to 1 to 3 is held sufficient. Then you have an interim order in this?
No, my lord. Date given to this.
Yes.
My lord, I have filed an application under order 3, rule 2 application. My lord.
Let's see. Where is the order?
Impugn order, my lord, page number annexure G, my lord. Para 33, relevant portion, my lord. Page number 37. The first defendant has executed GPA in favor of the first, in favor of his son, my lord. That is a petitioner herein, my lord.
Only thing is you have not produced the medical records.
Please, on that ground only, my lord.
Then
one more
produce the
thing,
medical
my lord.
records before the trial court.
Hello?
I'll set aside this order and remand. You produce a record before the trial court warranting.
And one more thing, the present, my lord, aged about 57 years, my lord.
57, aged about 57 is not a big age. Please
my lord.
come.
Please.
The present petition is filed. Agreed with an order passed on I number 12 under order 3 rule 2 of CPC. The facts of the case are the suit is for possession and partition. In the said suit, the defendant number 1 has filed an application under order 3 rule 2 stating that his father is unable to attend the court due to ill health and age-old ailments. After completion of the evidence of the plaintiff, the suit is posted for defendant's evidence. At that time, the present application is filed. That came to be dismissed by the court on the ground that no material is filed to show that the father is unwell or suffering from any medical issues. Accordingly, dismiss the petition. Notice to the petitioner has filed a memo seeking dispensation of notice to R4 to R7, and the court by order dated so and so has dispensed with. And though the summons was served on the counsel appearing for respondent 1 to 3, no wakalat is filed. There is no representation on their behalf. Next, having heard the counsel for the petitioner, there is a material on record considering the fact that the application is dismissed only on the ground that no medical records are filed. And as the petitioner is ready to produce the same, the order impugned is set aside. Accordingly, this court is passing the following order. The order impugned dated so and so is set aside and the matter is remanded back to the trial court, and the petitioner shall file the appropriate documents before the court. Yes.
39. Mohan Chandra P.
Waiting for the respondent. Raise time, Lordship, to file objection to main petition, Lordship. My lord, on the last hearing, your lordship directed me to produce the clarification order. I am producing clarification order regarding order 21 rule 97 court has passed order without considering my memo. Hence, your lordship directed whether it was a file order passed under order 21 or rule 58.
Seeking time.
Yes.
Is seeking time.
Short date may kindly be given.
Yes, there's this matter on 1st of September.
One more submission, trial executing court has issued once again warrant,
Huh?
attachment of warrant of movables.
That has to be questioned.
Same may kindly be stayed, my lord.
Lordship.
Because
Trial court had given a clarification, Lordship, regarding the.
Without questioning that order here, how will this court grant a stay? Yes,
date may kindly be fixed. My lord.
yes, September 1st.
Cell number 40.
Much obliged.
Cell number 40. Yes, Venkatesh Shastri.
I appear for the petitioner, my lords. My lords,
What about
with-
notices?
My lords, 2, 3 and 5, we have served on the counsel appearing for the trial court.
2?
3 and 5, my lords.
Memo is filed.
Filed on 24/7, my lords.
2, 3, 5. A memo is filed. Notice to the so-and-so is held sufficient. Then what about the other one?
1 and 7, I will take fresh steps again, my lords.
1 and
7, my lords.
1 and 7. The petition shall take out hand summons on the counsel appearing with the respondent and shall file a memo to
1
the.
and 7 were placed ex parte before the trial court, my lords.
Then make a memo.
I'll file.
Place some, seeking for dispensation.
I have no instruction on that, my lords.
Respondent 1 and 7, emergent notice. Yes.
Cell number 41. Hiranand, very lawyer for petitioner.
My lords, and
What are those 3 IAs?
my lords, one is for production of documents, and second one is for recall of the PW1 for chief examination,
And
one more is reopening for chief examination, my lords.
one more is?
Reopening of the stage for chief examination of PW1 and recall of the witness.
Reopening, recall and production of
Yes,
documents.
my lords.
Counsel submission
My lords,
is accepted. Yes.
this is a commercial suit, my lords, and after delay of 9 years, initially it was filed as a original suit, but later, because of the jurisdictional issue, this honorable court, by order dated 8/2/2024, transferred the matter transferred it to the commercial courts. After that, my lords, after 2 years of delay, they have filed an application for production of 33 documents. It's a commercial suit, my lords. The
Come to
court,
the order. Where is?
page number 18, my lords,
Reasoning
annexure
given.
A. The reasoning is at page number 27. Paragraph number 17, my lords.
It says that under 15, the court can do. Because, the court can adopt its own procedure.
Yes, my lords, but now they are producing 33 documents which were there in their possession. They could have initially filed it in the year 2024 itself, my lords.
Then counsel the petitioner submits that. After the suit is transferred to the commercial court, 2 years thereafter, the present application is filed. And why these documents are not produced, the court, without considering any of it, has allowed the application. Considering the submission, there shall be stay of operation of the order dated so.
My lords, one request, my lords, may I be permitted to serve the notice
will
on the
follow.
trial court advocate?
That will follow whether you ask or not.
Yes,
Yes. Notice and summons. Yes.
42. Joe Kerala.
Application, my lord, seeking it.
What is this office objection?
This office objection, my lords, regarding 2 IAs, my lords, were rejected.
What are the
One-
2 IAs?
One, my lords, for recall of the evidence stage, and my lords, to adduce 2 other additional witnesses. Both were rejected by way of common order. I have paid court fee, my lords, for 2 writ petitions also.
Reopen to adduce evidence of 2 witnesses.
2 additional witnesses.
Yes, the office objection with regard to the maintainability is overruled. Yes, where is the order?
My lords, IA, my lords, your lordship will find it annexure 154. Annexure-
Order.
Please,
First
my
we'll
lords,
see the
order, my lords, at page 103. My lords, on 1/7/26, my lords, I file IA. On the same day, my lords, without even providing sufficient time, my lords, to argue, then a trial court, my lords, rejects my application.
Let's see.
Please,
Or not?
03.
Hmm. What it reads, please read out.
Learned counsel for the plaintiff filed application under Order 6, Rule 1 and 2 CPC along with witness list. Further also filed application.
Where are you reading?
Notes
103.
103, second paragraph.
Counsel for the plaintiff, yes.
151 of CPC praying for reopen of the suit for further evidence of plaintiff side. Learned counsel for the plaintiff praised time for arguments rejected. Perused materials on record on appraisal. It appears that this court has framed issues on 11/2/2019. Cross-examination of PW1 completed.
You file an application. When the matter comes, you seek time for again.
The same day, my lords, I had filed application. It is not that, my lords, on the earlier occasion I had filed application and matter was posted for objection or arguments. On the same day, my lords,
Where do you
junior
get
colleague
that?
had
Where do you
appeared.
get that it's filed on the same day?
My lords, here only. In the orders, in the beginning itself, she says, learned counsel for the plaintiff filed application. And my lords, even my application on 1/7 itself, I have filed application. The date mentioned in the application also is 1/7/26. Apart from that, my lords, while closing, my lords, while the evidence of the plaintiff was closed, he filed a memo. My
Now,
lords.
when the case is posted for arguments,
Please.
again the plaintiff come up with this application. Your evidence was closed on 5/7/2023.
Please, my lords, kindly see page 63 for a moment, my lords. Page 63 of the order sheet. My lords, when the plaintiff's evidence was closed, plaintiff filed a memo, my lords, that seeking liberty to adduce.
Take notice, will not stay the proceedings. Notice to the respondents.
My lords, matter may be remanded back, my lords. I will argue the application.
How I'll remand without notice to the
My lords,
respondents?
for a moment, my lords, kindly page 63 for.
No, without notice to respondents,
My lords,
where
he
is the
will-
question of
the trial
remanding?
court will proceed with the proceedings.
This is not a case where we will be sending a wrong message to
My lords,
the trial
kindly see
court.
page 63 for a moment. Then, my lords, I will not press.
Yes, what is 63?
My lords, the learned counsel for plaintiff files a memo stating that he closes plaintiff's evidence, reserving liberty to adduce rebuttal evidence after completion of defendant's evidence. Memo is taken on record for defendant side evidence. My lords, I had sought for liberty. That liberty, my lords, memo was also
Liberty
taken.
will be availed after the arguments have started.
My lords, immediately, my lords, I have filed. It is not that, my lords, after-
2023, we are in 26.
my lords, defendant's evidence closed very recently, my lords.
When? How recently?
Please, my lords. Side close ಆಗಿದೆ, evidence close ಆಗಿದೆ ಇವತ್ತಪ್ಪ.
Next matter, please look into that.
Still number 43.
My request, my lords, let the trial court not to precipitate.
No, next matter, you tell the court, otherwise I will not.
43,
Please.
Hemavati Rajaram.
Lordship, I'm the defendant number 3 in this suit. The plaintiff filed this suit in the year 2014, in which he primarily questions a certain GPA that was executed in the year 1988. The main contention in this entire suit is that I, the defendant,
What is IA? Please come straight away to that point. Where is IA? Where is the order?
the IA is on page number 24, Your Lordship.
And the order is?
The order is on page 22.
Yes, let's go to that.
The order is on page 21.
Yes,
Apologies,
let's read the order.
The order says the operating portion of the order, evidence of both parties is concluded. That's the second paragraph, Your Lordship. Evidence of both parties is concluded. At this stage, advocate for defendant number 3 filed this IA and insisted to pass order on this IA before hearing final arguments and passing judgment through advocate.
I think I heard this matter before also.
No, Your Lordship.
Heard it.
I had not made any submissions.
About this, give the proceedings.
Your Lordship,
Yes.
Lordship, if I can come to the,
No,
I've not been.
because why I remember, then I expressed that the order was right.
No, Your Lordship,
The
I
order
have
was
not been
right.
heard. The order was?
The order of the court was right.
Your Lordship, I have some submissions to
Yes.
make, Your Lordship. It only raises, my writ raises a very narrow question. The question is whether after having entertained my application under section 340 CRPC, read with section 195 CRPC, whether the trial court could have refused and declined to.
The law on that.
There is this has been answered by
Yes.
a coordinate bench of this very honorable High Court, Your Lordship, in Dr. Praveen R versus Dr. Arpita.
Any Supreme Court judgments on this?
Lordship, I have also referred to a few other judgments. I may be permitted to read the relevant portion
If
of
you
this.
have a Supreme Court judgment, first please pass on that and
Your Lordship, on the next date of hearing, I will, but on this date of hearing, if I may be heard on why the ramifications are very huge for me at this point. Your Lordship, in the pleading, 30 seconds, I will make my submissions, Your Lordship. In the pleadings, the plaintiff is taking a contention that I have forged this GPA, and on the strength of this forged GPA, I have executed a gift deed in favor of my sons. He's also expressing his intention to eventually file a criminal case against me on the grounds that I have committed the offense of under section 420.
whether the perjury is decided by the court or not,
Your Lord,
he has an independent remedy of initiating the criminal proceeding.
Lordship. However, my remedy, this section 340 CRPC bars private prosecution. I will not be allowed to do anything. Your Lordship, there are only two outcomes that may happen and how it will affect me, and this is entirely against my it's
No, you
it
place the
prejudices
judgments.
me.
I have to hear it finally whenever you
I have provided this judgment.
Supreme Court judgment.
I have the Supreme Court judgment.
Please pass on. Give her a copy.
Copy.
Yes. Which para?
Para number 24, my lord, of the first judgment, yeah, 2009 Supreme Court 3232, first of the judgments. Para 24, your lordship.
Para 24 of the first judgment.
24, my lord.
Which page, sir?
Internal page?
My lord?
You are given some running page also number.
Yeah, I have. This is 1, 2, 3, 4.
You are referring to the judgment in
Yes,
case
yes,
of
yes.
Syed Askari Hadi.
Yeah, that's right, madam.
In that paragraph number 24.
24, my lord. 24.
Mm.
There is another consideration which has to be kept in mind. Subsection 1 of section 340 CRPC contemplates holding of a preliminary inquiry. Normally, a direction for filing of complaint is not made during the pendency of the proceedings before the court, and this is done at the stage when the proceeding is concluded and the final judgment is rendered. What the learned trial judge said was, I will consider 340 application along with the main matter when more so when the matter is closed at the
What is the next judgment?
The next judgment, Your Lordship, may kindly take to the another Supreme Court judgment, my lord. Para 6 of the second, Lordship finds it, para 6. Whether a statement made in the written statement is incorrect or false has to be considered and decided by the trial court itself upon conclusion of the evidence at the time of final determination of the suit, or if necessary in proceedings under section 340 of CRPC. Unless the aforesaid exercise is completed, it is difficult to say that the averments made in there are false and constitutes an offense attracting penal action. The last of the judgments by the coordinate bench of this honorable court, of course, citing several judgments of the Supreme Court, my lord, the last of the judgments, I would just ILR 2001 Karnataka, para number, last but one page, my lord, 4934.
Come to para 21. We can read from para 21.
Yeah, 21, my lord. 21 of the last of the judgments, my lord. Yeah. A combined reading of aforesaid quotations provision of CRPC and also IPC, as also subsection 3 of 195 CRPC, makes its legal position quite clear that they are applicable to any legal proceeding before a civil court or a criminal court, including a tribunal constituted by a central, provincial, or states, if declared by that particular act to be a court for the purpose of section 195. Therefore, if the family court finds, of course, that was a family matter. Family court finds that any party to the proceedings or a witness therein has intentionally given false evidence at any stage of the judicial proceeding or fabricated false evidence for the purpose of being used in any stage of the proceeding, and the family court is of the opinion that it is to expedite in the interest of justice that an inquiry should be made into the evidence referred to clause B of subsection 1 of section 195 of CRPC, which appears to be committed respecting that particular legal proceeding or in respect of particular documents produced therein are given in evidence. It may hold a preliminary inquiry, and if it thinks necessary, then it may record a finding to that effect and then proceed to make a complaint in respect of the particular offence or offences stipulated under clause B of section 195 to the concerned magistrate having jurisdiction against the said person. The judicial exercise involved in this process on the part of the presiding officer of the trial court calls for a prima facie determination of the fact if any such false evidence or fabricated documents bearing on the point and issues had been given or produced by a party to the proceedings or a witness therein. And this, the next paragraph gains importance, my lord. If any particular judicial or legal proceeding relates to a trial of a civil proceeding or contentious issues in legal proceedings raised therein by respective pleadings of the parties and which require final adjudication of the trial court on the merits of the evidence to be let in on record by the party in support of the respective case, then it goes without saying the most appropriate stage for the trial court in such trial proceedings is to formulate his opinion on filing or non-filing of complaint contemplated on section 340 of the CRPC would be at the final stage of the.
Now let us look at the judgment which she is relying on.
Yes,
please come to the judgment.
Of course.
Relevant?
Lordship, page 7. It's continuation of page 7, the last couple of paragraphs here. Lordship, it is a decision by a coordinate bench of this very honorable High Court. It says the courts are expected to do justice quickly. Justice dispensation system would be wrecked if statutory restrictions are not imposed upon litigants who attempt to mislead the court by filing and relying upon the false evidence, particularly in cases the adjudication of which is dependent upon the statement of facts. The purity of proceedings of the court cannot be permitted to be sullied by a party on relying upon false evidence inspired by extraneous considerations.
This judgment which is extracted, that how the court should view this perjury, allegations of perjury. You are on the point that your perjury application has to be decided at the threshold.
Lordship, I beg to differ slightly on that, Your Lordship. I'm not seeking for directions from this honorable court to decide the perjury application at this point. I'm only seeking that the learned trial court, after having heard me fully, it has taken me an entire year since the time I filed my application. They submitted their objections. I have placed everything on record to record a finding that prima facie there exists. Prima facie
that
there
cannot
exists
be done as a line of judgment of the Supreme Court. That is what I'm specifically saying from the beginning. That cannot be done.
Your Lordship, the facts of the case are slightly different over here. In the judgment referred to by,
you please tell me any other judgment deals with it.
I will, Your Lordship. I just have one more point. I will, on the next date of hearing. At this point, I just have one. I have produced all documents, everything that shows that.
My view on this point is it cannot be done. If you're saying that Supreme Court has said that it has to be done this way, I'll consider. Or else I have to dismiss your writ petition.
I will.
So
produce.
please come up with
a short date may be given, and I will produce the citations.
When do you want?
Next week.
Yes, this is a matter on 24th of August in the first list.
Gratefully much.
Number 44, K.S. Ravi Kumar.
I am appearing for the respondent in the matter, my lords. I undertake to file wakalat. I am yet to get instructions from the client. I've already received a copy of the document.
You for whom undertake to file wakalat for?
Respondent number 1 and 2.
So submit as instructions to file wakalat for 1 and 2. There is no representation on behalf of the petitioner. This is matter in the month of September. It's 45. Yes, 45.
Cell number 45.
In this matter, my lord, this matter was heard for some time, day before yesterday. I was directed to produce the copy of the RFA, order passed in the RFA, my lord. So my application filed seeking.
No, it also says about your non-taking of hand summons and all.
No, my lord, day before yesterday it was heard for some time. And so far as observation made in the RFA.
7/8/2026, issue notice to the respondent, petition take out hand summons.
Yes, my lord. But,
It was on,
on that time, Lordship was referring to the observation made in para 10 of the impugned order. There was a reference to judgment passed in the RFA.
what is order? Where is the order?
Annexure A, operative, the reasoning given is at page number 17, please.
Page number 17.
17. Annexure A. I filed an application seeking, I am the beneficiary under the will executed by JDR number 1.
Please read from the reasoning part.
Para 8, it is not in dispute that Srimati Sharpunisa, who is defendant number 1 in the suit, is no more. Decree holder and JDR number 1A, JDR number 2, JDR number 3, being the children of Sharpunisa already on record. Now applicant come up with application that is named to be implemented as legal representative of deceased Sharpunisa. On the ground that Sharpunisa during her lifetime on 2/3/1998 executed registered will and bequeathed scheduled properties to him. It is worth to note here that in suit, Srimati Sharpunisa filed a letter statement containing that defendant number 2 and 3, who are her daughters and their husband, have played fraud on her and obtained a signature on blank paper informing same are required for.
So this order I wanted to see.
This one.
Where is that?
Milad, in RFA, in
Yes.
page number 19, please, Milad.
Page number?
19. 18 of the particular article.
Page
Milad,
number 19.
19.
Please read.
That there are two properties, Milad. One property is in Ramnagar, that is Schedule A property. This particular property is in
No,
Bangalore.
it's not about property, it's about the right of that lady, which
Milad.
has been determined
Please,
for
Milad.
the order of the executing court.
Please,
So
Milad.
you please draw the attention of the court to that particular paragraph.
Milad, first paragraph, after the 5 lines, Milad. It is also not in dispute that B schedule property is purchased in the name of mother, that is defendant number 1, and none of the parties have disputed the same. It is to be noted that when the father of the parties have acquired schedule A property during his lifetime, did not execute testamentary document in favor of any of the parties and aided interstate, all the legal heirs succeeded to the property. Defendant number 2
Up
is
to para 25. Para 25.
25. It is to be noted that defendant number 1, who is mother of the parties, have categorically denied the execution of both the document exhibit D1 and D3, that is HIBA and gift deed. It is her specific case that defendant number 2 and 3, at the instance of their husband, have obtained signature fraudulently that their husband is required to lease out the property. In the cross-examination by learned counsel, counsel for defendant 2 and 3, it is elicited that she has filed a case in Ramnagaram and she does not know whether the suit is disposed of or not. She also admitted that she used to sign in Urdu and the same was confronted to her. She has denied the same. Documents are marked as Exhibit C1 to C3. It is suggested that she herself executed Exhibit D1 in favor of her son-in-law and same was denied. Milad, here, Milad, the HIBA that is under challenge before the suit. It is suggested that she herself executed Exhibit D1 in favor of her son-in-law and same was denied. Further, suggestion was made that after executing HIBA, possession was delivered and same was denied. It is further suggested that in order to knock off the property of her daughter and son-in-law, she has given false evidence before the court and same was denied. In the cross-examination of PW1 by learned counsel for the defendant 2 and 3, it is elicited that he does not know about the execution of HIBA by defendant number 1. It is further suggested that in the HIBA, he is also signatory to the document and same was denied. It is pertinent to note that the signature witness has not been confronted to PW1 during the course of cross-examination. When the defense has been taken that all the parties are signatory to the document, ought to have confronted the signature of the witness of the and same has not been done. It is pertinent. It is also important to note that DW1 has
At page 23, this finding is page 23.
Please,
That
ma'am.
paragraph, the first paragraph, about 10 lines from the bottom. The court below has given its anxious consideration.
Defendant number 1 is not having absolute right to execute the gift deed.
The court below has given its anxious consideration to both oral and documentary evidence and has also taken note of the material available on record and has given a definite finding that defendant numbers 2 and 3 have not proved the execution of the HIBA and the defendant number 1 was not having any absolute right to execute the gift deed.
The reasoning given is that the person who is propounding that gift deed They have not proved the gift deed by examining the witness. That is the reason for which it is.
No, it is about, she's not having any right to execute a gift deed
No, but there were
with regard to the property.
two properties were there, my lord. Schedule A property, it is a registered gift deed because it belongs to the husband. She cannot execute the gift deed. That is fine.
Here, for this court to consider your case,
Please, ma'am.
only thing what you have to, argue, to draw the attention of the court to any of the documents that are there. When the one who has executed a will in your favor,
Please.
in the earlier proceedings, when there is a finding that she has, in respect of a property, she has no right. When she has no right, question of issue, executing a gift or a will does not arise.
My lord, there are two properties. My humble submission is, so far Schedule A property is concerned, she is not.
For this finding, we have to look at the trial court's order, judgment and decree.
My lord, it is in so far as gift deed is concerned, they have not proved the gift deed. That's the observation made in the RFM.
No, forget about gift deed. Here on the will, not will, what is this? Gift deed.
Hiba.
It says not proving. They say that the trial court's observation is she has no right.
No, but so far Schedule A property, she has no right. my lord.
Where is
Schedule
that?
B property.
Where is that? Where do you get that?
My lord, here at in page number 18, please, my lord.
Page number?
18,
Huh.
after 5 lines. my lord.
Yes.
So, in the beginning, my lord, it is noted that there is no dispute with regard to the fact that a scheduled property which was situated in Ramnagaram was purchased by the father of the parties, White Shaley date so and so, and he died on so and so, leaving behind plaintiff and defendant as is here.
Now, what is the judgment and decree? What is there for execution now?
No, my lord, it is under execution insofar as Bangalore property is concerned, my lord. So here there is a clear finding that Schedule B property she has purchased in her own name. When she is having right, the finding is that the donees who are claiming right under the gift deed, Hiba, they have not proved the Hiba. Here the case is that the applicant is
Please show me the judgment which is now under execution.
well, it's a partition decree has been passed.
What are the rights of the parties as determined by the court?
So 1/6 share has been allotted.
Let's see, where is that?
Because I will produce, my lord.
No, unless and until the person who has executed a will
Please.
in your favor has any right, her will is not necessary to be considered in the execution proceedings.
Merely because, my lord, humble submission, the JDR number 1, the mother, she is also having 1/6 share over the
If that is a share, then we will consider, show that. If she is having a share.
My lord, I have produced the execution petition.
Where is that?
Annexure B is the
Court's
execution.
finding is that she has no right to execute a gift deed
Please,
because that is not her property.
please,
In respect of the very same property, if she executes a will in your favor,
please.
court need not entertain your application and need not take you on record. That is one. Your submission is that is only in respect of one property.
Please,
Other property is a self-acquired property.
please.
If it is a self-acquired property, what was the judgment and decree which is now under execution? I want to see.
In that judgment, my lord, the plaintiffs are given 1/6 share. Similar to that, JDR number 1 is she is also having 1/6 share. So appropriate share over the property, my lord.
Now, what is, by way of this will,
Please.
property is bequeathed on you.
And she has bequeathed the Schedule B property to me, my lord, in the 19, as per the annexure.
Will be property is the one where she has no right to do.
So far as her share is concerned, my lord, since she has left behind a will, I am entitled to the share which she is entitled to, because as per the will, because will as
Please place all those documents. Let me see. When?
Monday.
Monday.
Okay.
Same list, first.
Then number 42.
Yes.
28/1/26, my lord, defendant's evidence was closed. Thereafter, my lord, D1 and D2 expired.
When was this petition filed?
Application is filed on 1/7/26, my lord.
What were you doing from 1 to 7?
My lord, D1 to D2, they expired. Their LRs were brought on record.
What gives you opportunity? You don't do anything. And what is this litigation?
My lord, since D1 and D2 both were expired, my lord, first I brought them on record.
I think what is the general procedure before the court? When you file an application, you will be ready with that also.
Normally, my lords, they would give time, my lords, to the defendants to file objections. Then, my lords, arguments would be heard. Here, my lord, junior counsel, my lords, files an application, my lords, without even providing any.
Where is that order?
Please, my lords, at 103.
When counsel for the petitioner submits that he has filed an application under Order 16 Rule 1 and 2 CPC along with witness list, and on the same day, the court wanted the petitioner to proceed with the matter. The petitioner has asked for a time, and the court has rejected the same without any basis. Considering the submission, they shall be stay of all for the proceeding. Notice hand summons. Yes.
Sought for stay, my lords.
Granted.
Grateful.
Then number 46.
My lord, for the petitioner. My
Regarding
lord, the
maintainability.
office objection is that, my lord, I should have filed an appeal, my lord, under Order 43 Rule 1. My submission is, my lord, my suit for injunction was rejected. I filed a regular appeal. In the regular appeal, I filed an application under Order 39 Rule 1 and 2. Therefore, my lord, writ jurisdiction is maintainable, my anxious submission. A impugned order, my lord, your lordship may kindly peruse.
Is passed by?
Passed by the senior civil judge, my lord, in a RA.
No, yeah, again, is that a miscellaneous first appeal lies or a writ petition?
My lord, writ
To
petition.
file a miscellaneous first appeal.
My lord,
This objection with regard to the maintainability is upheld.
my lord, I may be.
Shall file an appropriate application within 2 weeks from the date of receipt of the copy of the order. The official return all the documents.
Please.
Keeping the copy of the order.
Liberty may kind.
Yes, 47.
Cell number 47. Dispose. 47. Sushma.
For petitioner, my lord. My lord, this is coming up on maintainability issue.
Yes.
The office objection. This is an ad interim ex parte order issued against me by the city civil court.
Then what should follow?
My lord, I have no appeal under
To file
43.
objections?
I will file my objections, my lord, but before that, my husband is trying to vacate me from the house. This is my matrimonial house.
No, that also you can tell the court. If the court is not hearing your case,
My
then you
lord,
will come here.
I will go back. The matter is posted for 17th, but before that, he's trying to file all kind of applications to the apartment association, trying to obtain the camera recordings of the house, trying to obtain the camera recordings of who's coming into the house. My parents are coming to visit me.
First of all, have you filed any application before the, or anything to be taken out of turn for the urgency of pleading?
My lord, I have filed an,
You have to, you should have done, you shouldn't have rushed to the High Court.
no, I will file my pleadings there, my lord, but before that, my husband is
Before
trying to
that,
vacate
that's
me,
what
and
I'm
this is the
asking. Why
only.
is the court powerless to pass any orders? Considering the urgency as stated by you? What this court can do, the trial court can also do. Plaintiff is also before the court.
My lord, at least I am seeking a relief of not allowing my husband to remove me from my matrimonial
How
house.
can there be such an order in his suit for injunction? Whatever the suit
He has filed for not to dispossess him. It is his own property, my lord. I have no rights, no joint rights also in that
What is
property.
this, what is the suit filed for?
Not to dispossess him from the property.
That
He
is
has himself
granted.
abandoned me and my son. He has himself abandoned me and my son for the last 3 months.
No.
He has been staying away from
When
the
his
house.
case is that not to dispossess, that means he is in possession of the property.
He is not in possession. That is the reason.
That will be decided by the court. How can
Yes,
we
my lord. Till
decide
then,
this?
I may not be allowed. I mean, he may not.
That goes contrary to the very pleadings of the parties, and now this court will not do it. When the matter is coming up, that day I will ask the trial court to hear your matter. When is it coming up?
17th, my lord.
Yes, the present petition is filed seeking the following prayer. Then counsel for the petitioner submits that the defendant is, the plaintiff is trying to is making all efforts to dispossess the petitioner. It is stated according to the plaintiff that he is in possession of the property, but according to the petitioner defendant, she is in possession of the property.
It's my matrimonial house.
It is a matrimonial home. Any of the disputes between the parties is trying to dispossess her. This court is not inclined to exercise the jurisdiction under 227. Now it is submitted that the matter is coming up before the trial court on
17th, my lord.
17th?
17th of August.
17th August. Any objections are filed? Have you filed your objections?
I will file my appropriate objection.
Without even
Served the copy last week, my lord.
If you file it, it will consider, isn't it? When will you file? Again, they will ask time.
No, my lord. I will file my wakalat and objection on
Immediately,
the
the
same day.
objection shall be filed by the petitioner. And on the next date of hearing, within from 11th, within 3 days from 11th, when is that? What is the date?
17th.
Within 3 days from 17th, the court shall decide the application, the objections. consider the objections filed by the petitioner herein accordingly disposed of. Yes, next.
Much obliged.
48. Jayaraj D.
My lords, in this there is a office objection pertaining to
Respondent.
IA number 3 and IA number 4.
What are those two IAs? What are those two IAs?
Two IAs. One is for the recall of arrest warrant, and one more is to show cause why I should not be arrested under the provision of section 51 of CPC, my lords. Because both are interrelated, there is a
Yes,
common.
the office objections are overruled. Yes.
My lords, coming to the case, now the
Yes,
case
the
I am the
impugned order.
yes, yes. The impugned order is at annexure A, my lords.
Page number?
Page number the 33, my lords. Page number 33, the reasoning.
Where is the reasoning part?
Reasoning of the order. It is on paragraph number.
There is no genuine ground made by the JDA to consider the present application. As the following order.
As in paragraph number 10, my lords. Paragraph number 10.
Number 3 under section 151 CPC. I number 4 under section 51 read with section so and so.
151 of CPC.
Are by rejected. Yes.
My,
Let's read the order.
yes, my lords. At paragraph number, because there is a reasoning of the order with pertaining to paragraph number 10. Moreover,
No, we can read from para 3. It's a small order.
Okay. Shall I start, my lords? Both the parties and their respective run councils are present, kept by orders on IA number 3 and 4. Peruse the record with regard to the IA number 3 filed by the DHR under section. Actually, it has been wrongly recorded, my lords. Actually, it should be JDR. And with the 151 of CPC seeking to recall of the order dated 10/6/2025, 6/11/2025, and 6/4/2026, permitting him to file application in order to substantiate that he is not liable to pay any amount to DHR in persons, the recovery of movables and his arrest does not arise. It is in this affidavit the JDR accompanying the application that he has paid arrears of rent during the proceedings in OS number 8619 of 2014, and he has already handed over the possession of the suit property to the DHR in compliance of the decree dated 28/1/2020, and as per the decree is liable to pay only an amount of rupees 14,812 against the cost, and apart from that there is no liability at his hand to satisfy the decree. Accordingly, prayed to allow the application. Next, paragraph number 4. The JDR has also filed IA number 4 under 51, read with section 151 of CPC, seeking an opportunity to show cause why he should not be committed to prison. It is in the affidavit of the JDR accompanying the present application that he will file detailed memo of calculation in respect of the amount he had transferred paid to the DHR and an opportunity be given to him to show cause why he should not be sent to civil prison. Para 6. The other side has filed their common objections to both IA number 3 and 4, wherein the DHR has contended that the decree and execution being dated 28/1/2020 has attained finality and binding on the JDR, and the JDR cannot interpret the decree in any manner contrary to the terms of the decree or evade compliance with obligations raised under the decree. Para 2. After considering all the objections raised by the JDR, arrest warrant is issued against him. The JDR has to pay rupees 9,900,000 wide memo dated so and so filed by the JDR himself. As per the decree, the JDR has to pay 20,000 rupees per month as damages from 1/10/2014 till he quits and delivers the vacant possession of the property. Para 4. The delivery warrant was executed on 3/10/2023. Therefore, from 1/10/2024 till 3/10/2023, for 118 months, the JDR has to pay rupees 20,000 per month, which comes to rupees 21,60,000, and including the suit cost of rupees 14,812. The JDR is in arrears of rupees 21,74,812. Para 5. Out of the total balance amount of rupees 21,74,812, the JDR has paid only rupees 1,50,000 on 5/3/2025 and rupees 50,000 on 16/4/2025. Therefore, he is still in arrears of 19,74,812. Para 6. He has paid court fee on the mean profit. The JDR cannot indirectly challenge the order already passed. Accordingly, prayed to dismiss both the applications.
Yes, I have seen the order.
My lords, my submission before the Honorable Court is that, insofar as the decree has been passed on 28/1/2020, my lords, the portion of the decree was having 3 portions. The first obligation was to hand over the physical portion of the property. I have handed over the physical portion of the property on 3/3/2020, my lords. 3/3/2020. The execution petition was filed by the decree holder on the very same date, that is on 3/3/2020. After obtaining the possession from me, the same date he has filed the said execution petition. That is the first submission. The second,
he can't file.
No, that is, it is before the, it is a premature execution.
No, there are two things. One is to give possession to him. The
My lord,
second thing is about the amount.
I'm making my
About the
submission.
amount, damage to be paid.
Now coming to the second submission, my lords, it is a premature execution petition which has been preferred before the appeal period. And the third aspect is the prayer of the execution petition talks about 14,812 rupees is the prayer, which has been sought by the decree holder. And the decree that has been passed by the trial court, decree court, it has been clearly mentioned the court fees for claiming the amount of rupees 20,000 rupees for the number of months until the possession of the property. The necessary court fees should have been paid by the decree holder at the time of filing the said execution petition. Thereupon, on 16/7/2022, he files an amendment application, to amend the prayer and to claim the damages. Then thereupon, on 29/2024, when the amendment application will be allowed by the execution court. On 29/2024, he will pay the court fees, which is about 4 years, 8 months from the date of decree. My submission before this honorable court, and he has filed 3 memos for calculation. All the 3 memos have the different calculation altogether.
What is your calculation?
My last, my submission before the honorable execution court is that the decree has been satisfied is my first submission, and the second submission.
Where is the calculation that about the decree being satisfied?
That is the only reason I asked for the show cause, my last. To show cause, because
Show cause notice is given to you long back.
No, my last. Show cause.
I will not interfere in this order.
No, my lord, there is my lord, there's one more
unless
submission.
and until amount is paid, I will not.
My lord,
what is the amount you're going to pay? Then I'll hear anything.
My lords, I'll take instructions, I'll deposit. My lords, I will pay deposit.
I will post it tomorrow, you get instructions.
My lords, let it be taken up on Monday, my lords. I will pay 2 lakh rupees before this honorable.
What is outstanding?
My lords,
Not
the
even
submission.
50%.
19.5 lakhs is the outstanding.
Coming up with your calculation, you please come up with your calculation. As per your own calculation, 50% of the
amount. My lords, because it has been recorded in
the amount shall be paid.
My lords,
or else I'll not interfere.
My lords, it has been recorded in the by the honorable execution court that 9,900,000 rupees is the admitted amount is what they have recorded, because I was not the advocate on record at that point of time, because 18/6 is the time.
Come up with the calculation on Monday.
My lords, even by taking into consideration of the calculation that
come up with the calculation. You have the judgment and decree. You have 14 is the decree. 2020
Yes,
so and so date you have delivered position.
And
as per that, what is the calculation?
Yes, my lord. And there is one more submission, my lords. As far as the mean profit is concerned, it has been specifically mentioned in the decree that there will be a separate inquiry. Which
come up. I'll consider it on Monday in the first list.
Much obliged. Please.
Number 49, A. Madhusudan Rao, for petitioner.
Let there be an order to that effect to deposit 50% of the.
No, I will deposit to the court, man, because the whole submission.
We'll see.
Yes, please.
On Monday.
Much obliged. Great.
I have filed one writ petition challenging a common order wherein 2 applications for impleading have been rejected, my lords. And I have paid the necessary court fee. My lords, the impugned order is at Annexure J.
Yes.
Suit for specific performance, ex parte decree was obtained by respondent number 1. The LRs of the vendor filed an appeal before the first appellate court, my lords. In the meanwhile, the respondent number 1 has alienated the property in favor of respondent number 2. And respondent number 3 in favor of respondent number 2 in favor of respondent number 3. So there are 2 sales which have happened subsequent to the filing of the appeal, my lords. We filed applications to bring
When was the judgment and decree?
Judgment and decree was, my lords, I have produced it as Annexure B. Date of the judgment is 24/7/2019. What has happened, my lords? I
filed the appeal.
Appeal was filed in 2023, but it was renumbered in 24. One submission.
Sales were taken place.
The first sale has taken place in 2023. Admittedly, execution petition filed by respondent number 1 has been dismissed, my lords. He has not obtained a certified the sale deed from the court, my lords.
Take out notice.
My lords, the problem is the matter is posted for final arguments on 20th of August, my lords. That is this week. And absolutely no reasoning by the first appellate court, my lords.
And what were you doing till now?
I filed the application. Order was passed only now, my lords. It was passed on 17th of July.
When did you file the application?
13th of July. One application was filed as early as in 2023 itself. But it was adjudicated only in 26, my lords. Your lordships may kindly see the date of the order, 13th July 2026. I have immediately...
19 suit, ex parte judgment decree, appeal 23.
As soon as I got to know about the sale, I have filed an application. Your lordships may kindly see the
and
first
when did you
application.
come to know about the judgment and decree?
In 23, my lords.
What were you doing? You were not contested the matter.
No, my lords, we
Why?
did not. What has happened was the original vendor was the son of the appellants, the petitioners before your lordships. They are aged persons, they are illiterates, they had no idea about this. Admittedly, this is a joint family property, my lords. In that background, an appeal was filed. I also want to place the execution papers before your lordships in the next date of hearing. Your lordships may kindly grant an order of stay of the
Come to
proceedings.
the order.
Order is at page number, annexure J, my lords. Page number 72 onwards is the reasoning, my lords. Paragraph 12, appellants have filed IN number 2 and 5 under Order 1, Rule 10 and 10.2 of the CPC, praying to implead Sri Chandrasekhar Shivacharya Swami and Srimati Purnima as proposed respondents 2 and 3 in this appeal. The Honorable Supreme Court in Civil Appeal number 2095 of 22 between P.
Which judgment this court has relied on?
This is the judgment in which, my lords, I have not extracted this, but my lords, in this, this judgment, what they say is they may not be a necessary party. Because they can
What
join.
I'm saying, is it a old judgment?
It is an old judgment. There is a latest judgment of the
Please
Honorable Supreme Court.
for the petitioner submits that in a suit for successive performance, an application is filed to implead the subsequent purchases that came to be dismissed by order impugned. It is submitted that in the light of the latest judgment of the Honorable Supreme Court, even the subsequent purchases are also proper parties to the suit. Considering the same, there shall be stay of all further proceedings, notice and summons.
Much obliged, members.
Regarding objection number 2. Objection number 2, my lord.
What are those IS?
I recall and reopen, my lord.
Yes, the office objection is overruled.
Kindly
Please
out on
come to the
Monday.
order.
Kindly out on Monday.
It will not come on Monday. If you're taking a chance, let's sit on 25th of August.
Please.
Yes, 51.
Number 51, Avinash P. Petitioner Nagbhushan R.
For the respondent number 6, my lords.
Lords, praise time for amendment of the prayer, my lords.
Lords, the
Order.
prayer, no interim order, my lords. The prayer itself says that they wanted to quash the legal opinion issued by respondent number 2 and 3.
Oh, that matter.
Yes, my lords.
What is amendment? Now, what will you seek in this? That's what last time when the matter was argued, that's what I said. I'll dismiss it. He has sought for time and now it is coming.
And
What
short
is
accommodation, my lords.
whatever is the remedy available to you, you file a fresh writ petition. I'll give you the liberty.
That's one short accommodation, my lords. Senior will address the bench. Kindly.
Writ petition is filed questioning a legal opinion. All kind of innovations are happening. Yes, this is matter in the month of October.
Great.
Number
Yes, please.
52, Uday K.S. Interlocutory orders. The HP.
For petitioners, my lords. My lords, counsel on record is not will, my lords.
Yes, just in the month of September. Yes, next 53.
53,
Yes, in the month of October.
number 54,
Petitioners.
My lords, for respondents. My lords, 53 was there. Yeah, 53 was
You
there.
appear for 53.
Yes, ma'am.
Yes, you call 53.
number 50,
After 54 is called, all of you have raised.
My lords, we were under the impression 54 is our matter. It was under that impression. I'm sorry. Lords, this petition is arising out of an execution, out of a compromise petition. My lords may take it page number 77. The defendants hereby undertakes to file an application before the registrar of the companies Karnataka for closing
where is
change.
the impugned order?
The impugned order is, my lords, arising of the impugned order itself. Before that, my lords, there was a petition filed and there was a
So
compromise
that
petition
To
filed.
save the court's time, let me
Yes,
understand
my
from
lords.
the impugned
Yes, my
order.
lords. Page number 120. my lords. Page number 120 of the execution order. Operative portion of the order is at page 120.
We'll read from 5, para 5.
Yes, my lords.
You are
The decree holder.
You are the?
I'm the judgment data. my lords. The decree holder filed the suit in OS number so and so with the claim of the judgment debtor are infringing the trademarks, trade name of the plaintiff, and the said suit has been compromised between the parties as per the order dated 29/7/2014. The decree holder filed the certified copies of the order sheet in OS number 71.
I think this matter has come up the other day.
And my
ma'am.
lords,
Yes,
this matter has come up on 17th of July. The advocate for the petitioner said that he will file an affidavit saying in 2 months he will file the application before the ROC. That affidavit has not been filed until today.
It's ready, my lords. We are ready to, we have done everything. My lords, last occasion, it was ready, but it was not listed.
My lords, I have not got a copy of it.
I'll just give it.
Look at it. Give him a copy of it.
Yes, ma'am.
And you don't have to go into any other aspects. Take that.
My
affidavit.
lords, it's a compromise decree where they have.
Look at it, what he has said. Only you'll be able to submit whether it is
I'm
acceptable
only
to
seeking
you or
90
not.
days time to close it up.
Huh?
90 days time. At para 5, I have requested, my lords. At para 5 of my affidavit, I
Initiate
further
the
submit that I
process
have
in the
initiated
register
the
of-
process before the registry of companies for closure.
And I have filed the application.
And I have filed the application.
All probability that it shall strike out my name in the ROC. This is the only dispute, isn't it?
Yes, my lords.
Yes, my lords.
So, yes, no, if the procedure is taking time, what is that we can do?
No, no, my lords, I agree, my lords, but my lords, this seems to me like a receipt and extract from the MCA website. Where is the application which he's made for? My lord,
Application is with the authority, my lords. I have to apply for it and again get it.
my
For
lords,
there is
there
they have
seems to
given
be
an
some-
acknowledgement. Without filing an
Where is
application,
the
how will they give an
acknowledgement? Where
acknowledgement?
is the acknowledgement?
First sheet, my lord.
First sheet, what did it say? Satisfaction of charge dated.
Ministry of Corporate Affairs.
This is certified that the person to the provisions contained in so and so. The above charge for ₹2 crore.
Fee for STK2.
Has been satisfied on 23rd of January 2026 in accordance. How much time it takes? It is. It is
90
in the
days
month.
it takes, generally it takes 90 days.
You have done it on the 23rd of January 2006.
My lords, the next page, my lords, the next page, Ministry of Corporate Affairs. Service request, it was made on 13/7/2026, last month. 13/7/2026.
Yes.
My lords, if at least a copy of the application, because STK2, I will not understand just
Really,
by-
they are riding a dead horse, my lords.
my
Nothing,
lords,
my lords, 2014 itself, I'm
I'll
not doing
tell you,
anything.
I will record it.
Yeah.
Record their submission that
Yes.
they made an application on this day.
Yes.
Within 90 days, it will be over.
Yeah.
If without filing an application, if this kind of a statement is made, that amounts to perjury.
Yeah, if
They'll be responsible for the costs and consequences.
yeah, if it doesn't come correspond to an application for change
I'll
of
record-
striking
I'll
of name,
record
then
all
I
this.
can.
When the matter came up today, Land Counsel for the petitioner has placed before this court an affidavit wherein it is at para number 5. It is stated that he has initiated the process before the registrar of companies for closure or removal of striking of Therapeutic Bedding India Private Limited in the capitals and file the application STK2 form before the ROC. And in all probabilities, within 90 days, the ROC shall strike off the name. He has also placed before the court the receipt in support of the same dated
13/7/2026.
13/7/2026. Land Counsel appearing for the respondent submits that application filed before the Register of Companies is not placed before the court. It is a submission of the Land Counsel for the petitioner that though that application is not placed before the court, this proceedings dated acknowledgement dated 13/7/2026 shows that they made an application for they have applied for the same before the Registrar of Companies. Considering the submission of the petitioner that already an application is filed and it is likely to be the name is likely to be removed within 90 days from 13/7/2026, lists this matter on 15th of September. On 15th of September, if as stated by the Land Counsel for the respondent, if the application as such is not filed or any submission that is made, any wrong submission is made, the petitioner will be liable for all the consequences.
Interim order may be extended.
Interim order earlier granted is extended.
Till number 54.
That's ROCs, my lords, it is the job of the ROC, my lords. There is nothing left out from my end.
Only thing is your duty is application.
I have done it, my lords. I've done it.
On that.
Even if my lord
If
says that I'll present it in the office also, the
No.
application.
When they pass the order.
Yes.
Is a different issue.
True.
He is only his apprehension.
My
is
approach,
whether-
I have done it.
Whether you have done it or not.
I have done
So
it.
For
my
that I
lords.
said.
To that effect, with a memo, I'll also file it in office also.
Better you file it.
Please, my lords. Grateful.
Yes.
54, Pallava R for petitioner.
My
For
lordship,
this point number 5.
appearing for the petitioner, lordship. My lordship, the matter here is for hearing on IA number 1, which is filed seeking stay in an OS 1524, which was filed based on the liberty granted in the trial court. If I'm given time, if I can just take you on the brief of this.
So what are this IA 1026 for direction filed by advocate for petitioner? Furnishing of issue notice to R1 for second time. You appear for whom?
My lord, I'm for respondent number 5.
What about respondent number 1 notice? It's a 2025 matter.
My lordship, I'll just take steps on that, lordship.
Yes.
My lord, in fact,
With an
this,
agreement,
My lordship.
it stays there.
Yes, my
there, my
lordship.
Give that.
this IA is for stay is there, but the honorable civil court is proceeding with the new proceedings in the new original suit, my lord, which is subsequently filed. But in fact, this
Keeping open the issue of maintainability, if any, by the respondent, there shall be stay of operation of the order dated 24/7/2025, passed by the 7th additional senior civil judge. What is that order? Give that file. Yes, where is the order?
My lordship, the
Page number
order was
25, ma'am.
passed on by the trial court on the IA filed by the plaintiffs on an application filed under Order 23 Rule 1 seeking withdrawal of the plaint.
We'll see that
Sure.
order, what it is.
the order is at page number 25, my lord.
Annexed, your lordship.
Let's see the order. When was the suit filed?
2008, lordship.
2008 suit, now you want to withdraw?
After,
My lord,
You are the plaintiff in the suit?
I'm for the plaintiff.
my lordship, after 14 years.
My lord,
Yes.
my lord, there was a misunderstanding because 50 years ago was the contention from the other side, defendants, that there was a oral partition within the family. But the revenue records did not reflect anything of the sort. Lord, all the scheduled properties continue to be in the name of the prepositors of the family. That is my grandfather. I'm the plaintiff. My grandfather, Kenche Gowda. He had 3 sons, my lord, and I'm the son of the second son, Made Gowda. Male Gowda was the first son, and Kare Gowda was the last son, the third one. These two remained in the ancestral village, your lordship. And my father shifted from the village
When
to
did you
Sindhe
realize all that? How many, you require 2-3 decades to know that? File a suit in 2008.
My
And
lord,
in
file-
2026, you file the application under Order 23 saying that you want to withdraw the suit and file a fresh suit.
My lord, that came to light, and one more fact also came to
When
light.
did it came to light?
Towards the end of 2024, my lord. So in the year 2025, on 22nd of February 2025, this application was filed, your lordship. And one more fact was that there were other scheduled properties which were not.
To it, if you had come to your knowledge, why should you withdraw the suit? You can include them as part of the suit, part of the scheduled
My
property.
lord, the thing is that it was learned later on that there was a partition, but it was not reflected in the revenue records. The revenue records continue to be in the name of the grandfather, my lord.
Why
So
those pleas cannot be taken in this suit? As it has come to your knowledge, why should you withdraw the suit? There should be something that
It would
which you cannot rectify, or what are the reasons that you have stated?
it was first filed for partition and possession. Now it had to be filed for declaration and possession. So that was a difficulty. Because with respect to 2 scheduled properties, one at serial number
If it
45.
is granted, you will get the relief for the declaration from 2008 till now.
I didn't get that.
2008 and
Yes, ma'am.
2026, how many years?
Yes, my lord, I understand the difficulty. But then
My lordship, but also there was an amendment plaint that was filed in
When the court
2021.
is in your favor, why do you want to argue? Yes, please come. Agreed with the order passed on IA under Order 23 Rule 1 CPC by the 8th Additional Senior Civil Judge and JMFC Mysore dated 24/7/2025. The defendant is before this court. The plaintiff has filed an application to withdraw the suit with the liberty to file a fresh suit It is the case of the plaintiff that the suit is for partition in separate question due to lack of knowledge. Earlier partition with respect to some properties were not informed to the council. There are many other properties to the partition among the joint family members. In order to rectify the same, the suit requires reframing of the pleadings and prays to withdraw the suit with the liberty to file fresh suit. The defendants have filed their objections. The court, by order impugned, has rejected the said request, observing that after careful consideration of the material placed on record, it appears that according to the plaintiff, some properties of joint family were partitioned and some required to be partitioned among the joint family members through this suit. However, earlier partition with regard to some properties revealed in the above suit, hence this application for the purpose of reframing of the pleadings. This application is not allowed. Plaintiff will suffer and it can be compensated by any means. There shall be an opportunity to the plaintiff to contest the matter. The same cause of action ensues of the process. Accordingly, only objection is accordingly IA deserves to be allowed. Accordingly, the court has allowed the IA permitting to withdraw the suit with the liberty to file a fresh suit on the same cause of action. Agreed thereby. The defendant is before this court and counsel appearing for the petitioner submits that the suit is filed in the year 2008. Why the reasons that are stated by the petitioner, plaintiff, or that can be, it is not a case that the mistakes cannot be rectified. Now it is submitted that now it is stated, now they want to seek a declaration after after almost 2 decades, and the court has failed to consider all these aspects and allowed the application. This court application and counsel appearing with the respondents of this act. The court has rightly considered the scope of 43 Rule 1 CPC and had allowed the application, and there are no grounds to interfere. Having heard the counsels on either side, there is a material non-record. The suit is filed in the year 2008. Now, according to him, there are some more properties. Earlier, there was a partition and certain new facts they want to come on record. And according to them, all these aspects have come to their notice recently. It is not a case that this case does not fall under Order 23, Rule 1. The petitioner, the court, just like that, by giving the liberty, as in fact is condoning the considering and is permitting him to seek declaration after 2 decades. That is not permissible. Hence, in the considered opinion of the court, the order passed by the court permitting the plaintiff to withdraw and file a fresh suit is contrary to the settled legal position. Accordingly, I number, so in the order passed, the order impugned dated so and so is set aside.
My lord, now one thing happens that original suit is withdrawn, my lord. That's not on the file of the honorable court, so it cannot be restored, my lord.
My lordship,
That
it
cannot
needs to
be
be
restored.
Stay here.
Stay is there.
How can it be withdrawn? Stay is granted by the coordinate bench long back.
My lord,
My
it was
lordship.
already withdrawn and fresh suit is already filed.
My lordship,
They
before
are
we
in,
approve,
my lord, they are in fact
When was the fresh
represented
suit
in the
filed?
fresh suit.
When was the fresh
My lord,
suit
I'll give
filed?
the dates.
my lordship,
My
the
lord,
fresh suit
1
was
minute.
filed in 29/25.
My lord, may I? My lord, fresh suit, this impugned order was passed on 24th of July 2025. After 56 days, my lord, new suit was filed on 20th September 2025. My lord, the order sheet is also provided at page number
The stay
7.
granted by this court. Look at it.
5/12/25.
Then what remains?
My lordship,
My lord,
we
they
were,
are present before
until
the
the
honorable court
notice
in the
was
new suit.
issued in the new case, in the fresh suit that was filed, we were unaware of the
Forget about his proceedings. When an order is passed, you should come to the court at the earliest.
My lordship, there was certain delay that we
But we
approached,
can't
but
help it. By the time he has
my
already filed
lordship,
the new suit.
it was just like
My lord, they
The
have
submit-
even
within a
filed.
month of time
the-
that we actually took.
The check of the earlier order. It is the writ petition is filed seeking the following prayer. A coordinate bench of this court has granted an order of stay on 5/12/2025, but on 24/7/2025 is withdrawal.
That is the passing of order, my lord, the impugned order.
Impugned order is passed on 24/7/2025 and 20th September 2025. New suit is filed and the impugned order is passed by this court on 5/12/2025. Considering the fact that already the old suit is withdrawn and the new suit is also filed, nothing remains to be adjudicated in this petition. Accordingly dismissed. Yes, next.
55, Nataraj Baba, K for petitioner.
Appear for respondent number
Neprakash.
1, that I have filed an application for vacating the interim order.
Only interim order is not to alienate the suit shall property, my lord.
So,
Suit for declaration.
Yes, we'll decide it.
Please.
Please come to the impugned order. Where is the impugned order?
impugned annexure A. Mother, only ordering issue of emergent notice, this writ petition is filed, mother. Such a writ petition itself is not maintainable. And now I have filed a statement of objection
To
to
the order
IA,
sheet.
and also I have filed a written statement also in the trial court. This is the order. It is just and proper to hear dependents on IA number 1 and 2.
How can there be a stay like this?
One judgment, my lord.
What judgment?
In the similar circumstances, my lord.
No judgment will be there saying that if the court will refuse to grant it has not refused. It has issued notice. Then what is the course to open? We will ask the court to immediately decide it. No, here with one line, if you say injunction, when we are telling the trial courts to pass an order on injunction, looking at a prima facie case, balance of convenience and irreparable loss, and how the High Court can grant you an injunction with just one line order. That is contrary to law. I'll set aside this order.
That's with the trial court to consider IA number 1. Till that time,
I'll ask the court to decide it within 1 week. This application to be considered within a week. Now anyhow, he is having the advantage of this order till 12/2/2026. We'll say it shall continue till such time and the court shall not be, shall not be impressed by this order. That I'll record.
Next date is 2/9.
On the day it shall decide.
Your lordship may kindly direct the trial court to dispose of the IAS within.
Yes.
Because issues have already been.
Yes, I'll direct.
And
Please come.
the suit is posted
Yes.
for evidence.
Yes.
At
The
this
present writ petition is filed, seeking the following prayer. Seeking the following prayer. Where is that prayer? The petitioner has come before this court to set aside the impugned order. There is no order at all.
No order.
The writ petition is filed questioning the order dated 11/2/2026, wherein the court has issued suit summons to the defendants in the IA that's filed seeking ad interim injunction. When that order is questioned before this court, a coordinate bench of this court, by order dated 12/2/2026, directed the parties not to alienate, encumber, dispose of, or create third-party rights or the sue scheduled properties till the next date of hearing. That interim order is continued from time to time. When counsel appearing for the petitioner submits that, when counsel appearing for the petitioner submits that, when an application, when counsel appearing for the respondent filed a vacate petition and submits that, when the court has issued only suit summons, that is not an order in the eye of law and that cannot be questioned before this court. And and there cannot be any order of injunction in this, in this writ petition with the prayer that is sought. You extract the entire prayer also, with the prayer that is sought. This court has perused the order and also the order passed by the coordinate bench of this court. A coordinate bench of this court in so and so, that matter is there. No? The in so and so as observed as follows. Whenever an application is filed seeking ad interim injunction, the courts have to consider the same and pass orders in accordance with law. But just like that, they cannot issue suit summons to the defendants. Now that has led to an order of injunction by this court, and the matter is pending before this court. Considering the judgment of the coordinate bench of this court is passing the following order. The writ petition is disposed of, directing the court to consider the application in accordance with law within a period of 1 week from the date of receipt of the shall consider the matter on the next date of hearing, that is on 19
29, my lords.
29. 2nd
29.
September.
29.
They shall consider the IA on 2/9/2026 or within 3 days. If it is not possible on that day, within 3 days from that day. Number 2, the petitioner is having an interim order from 12/2/2026 that shall be enforced. Number 3, this interim order is granted by a coordinate bench of this court without recording any reasons. Hence, the court, hence there is no appreciation on the merits of the matter. The court, uninfluenced by any of the interim order that is granted by the court, shall decide the application in accordance with law.
Cell number 56, Somshekaraya RP.
Is that the order sheet? Yes. Yes.
Like in this case, my lord, the property which was mortgage.
What is the impugned order?
Like impugned order passed on the IA and
Where
the
is it?
limitation, my lord.
Where is it?
My lord, that is I think page number 198, my lord. Before that, my lord, some.
No, before that, we'll see the order.
Please, my lord.
190?
198, my lord. Annexure Y.
When was the order? Order.
Order dated 10/3/26.
10/3/26. Not this order.
Please, my lord.
When was the judgment?
Judgment, my lord, in the year 95, my lord. However, the recovery certificate stated to have been issued on 29/2/2000.
I'm sorry, my lord. The order dated 29/2/2000
29/2/2000.
and the recovery certificate is dated 21/5/2001.
22/9/2000 is the order.
Please, my lord.
Recovery certificate is issued on
21/5/2001.
21/5/2001.
Please, my lord.
And when was the execution filed?
The recovery certificate continued, my lord, before the Honorable DRT, after which, my lord, the debt was assigned by the bank in favor of a private individual by way of a deed of assignment in 2010. And accordingly, my lord, the recovery certificate, the execution of the recovery certificate was sought, transfer was sought from the DRT to the Honorable City Civil Court, which was granted. That was challenged before this Honorable Court. That petition was withdrawn. A second challenge was made. The transfer was held to be legal. A third challenge was made. That was withdrawn. They went to DRAT. There the appeal has been dismissed. Now, my lord, they filed another petition before this Honorable Court challenging the maintainability of it. This honorable court directed the city civil court to order on the maintainability. Now, my lord, pursuant to this honorable court having already held that the petition is maintainable, the transfer is maintainable, the learned city civil judge passes an order holding that the petition is maintainable. On that, my lord, there before your lordships. This is the fourth round of litigation, my lord, and the execution is being on after.
Where is it decided that the execution is maintainable?
Right. That is the impugned order, madam. Page number.
No, earlier
Difficulty, my
round
lord,
of litigation.
the difficulty, my lord, is none of it is placed.
Yes.
May I just
Take that.
May I say this, my lord? Notice has not yet been ordered to me, my lord, but they reported in the city civil court that this petition had been filed. Therefore, I have come, my lord, and filed the wakalat in the office today morning.
Let's see.
Lordship may kindly come to the first challenge,
Mm.
my lord, which is at page number 38.
Mm.
This is after the transfer had been done, my lord. The copy of the petition is at page 38. May I kindly request your lordships to kindly come to page number 44, ground number 2.
Yes.
The order in OA number so and so has been passed on 29/2/2000, and the order under annexure A was passed on 20/12/2019. By that time, the execution was barred by law of limitation, and when the execution was impermissible to direct transfer, that too without a notice to the other side was wholly impermissible. This is the challenge, my lord. This is one of the ground. I filed my objections. My objections is from page 49.
Come to the order status.
My lord, order is at page number 55. Operative portion, para 57, page 57, para 2. Petitioners are guarantors to a loan borrowed by the third respondent from Indian Bank. The recovery proceedings initiated by the bank in so and so stood decreed by the DRT. The bank has assigned the debt to first respondent. First respondent has filed an application for DRT on 18/12/19 seeking transfer of recovery certificate of City Civil Court Bangalore to enable the assignee to execute the decree passed by the DRT. The DRT has allowed the same by order dated 20/12/19. Petitioners have challenged the impugned order on various grounds. They have also deposited in all 10 lakh before this court in these proceedings. So and so for petition seeks leave to withdraw this petition with liberty to challenge the impugned order before the DRAT.
That is transfer of the debt.
Transfer of the decree. The ground, my lord, was laid that it is not within the law of limitation.
So this is dated
This, my lord, is dated, order is dated 7/12/2020.
7/12.
2020.
Then they went before the DRT.
Prior to going to the DRT, my lord, they filed another petition before this honorable court in 42/58 of 21, my lord, which is at page 59.
Why?
They again, my lord, challenged the issuance of the notice subsequent to the execution petition having been taken over by the city civil court. A notice is issued to the petition, the judgment debtors. They challenge the issuance of the notice. And kindly see, my lord, what this honorable court has already held.
Yes. Paragraph.
Page 61, madam, my lord, para 2.
Yes.
Having heard the learned counsel for the parties and having perused the petition papers, the court declines to grant indulgence in the matter inasmuch as the liability of surety or guarantor is coextensive with that of the principal borrower. The first respondent having bought the recovery certificate stands in the shoes of the lender, and therefore the award granted by the DRT in favor of the lender ensures to the benefit of the first respondent assignee thereof. The said certificate being treated as a deemed decree is put in enforcement in the subject execution case that cannot be faulted on the grounds urged in the writ petition. The above apart, the petitioner had unsuccessfully fought another case in so and so in laying a challenge to the orders arising from the DRT proceedings, and the said writ petition is said to have been dismissed on the ground of availability of alternate remedy of appeal. The relief which the petitioner has sought for in this petition thus could not have been obtained at the hands of the DRT. Even now it's open to the petitioner to avail the alternate remedy. The contention of the petitioner that the award of the DRT or the certificate following the same. So, my lord, this is second challenge. No, my lord.
This is dated.
This, my lord, is dated. I'm sorry, my lord, I'll give 3rd March 2021. Then, my lord, they approached the DRAT. I'm sorry, my lord, I was in DRAT. I was not a party to the proceeding. There, my lord, they failed to deposit the money required for challenging the DRAT and the Securitization Act. Therefore, on that ground, my lord, the petition has been dismissed for default. Lordship will find it at page 66, serial number 26. This is a printout as was available on the DRAT website, my lord. No sorry, got it. KC Ravishankar and others versus MR Rajat. No representation for appellant, learned counsel, so and so for R1 present. It's represented that pre-deposit as ordered on 22/9/21 by this tribunal is not made. And as per the conditional order, the appeal has to be dismissed.
Page you are reading?
I'm so sorry. 66, my lord.
Yes.
Serial number 26, my lord.
Serial number 26.
26.
Yes.
no representation for appellant so and so. Learned counsel for Shri G. Sajivi for R1 present. Appellant is not even present.
Rejected on which date?
Which on 17/4/22, my lords, it appears in a very small font on the top of the page.
Then after that?
Then, my lord, they filed another petition, my lord, on 11th in 4027 of 24 at page 67. I'm sorry, my lord, I don't have a copy of the petition because prior to the issuance of the notice, they proceed to withdraw it. What was the
11th March 2021.
11th March
But
2024?
the other matter was on 3/3/2021 dismissed.
It was dismissed. Then they approached the DRAT. DRAT, they didn't complete, is dismissed. Then, my lord, the execution petition proceeds in the city civil court. Then they again approach this honorable court.
There is something wrong with this number because
I'm
before
sorry.
the DRT it is rejected on 17/4/2021.
22, my lord. 17/4/22. I'm sorry.
17/4/20.
22.
Then this is on
This, my lord, on
March 24.
24. Now, my lords, if I may say this, my lord, here prior to the issuance of the notice, this petition is withdrawn by the petitioner.
Seeks leave of the court to withdraw. The
I
WP
do
is
not-
filed praying to quash the execution proceedings in execution number 445 of 2020 on the file of the city civil court.
My lord, what were annexure P and Q? I'm so sorry, my lord, but I'm unaware of it. But 2/3/2020, if my memory serves me right, my lord, was the attachment order passed by the city civil
No,
court.
please come to this order. Come to this order. And in this petition, have you stated about all this synopsis about the relevant dates?
May I submit one last? There's one last judgment of this honorable court where they approached this honorable court in WP number 1156 of 24 at page 70.
Page 70.
Please.
Yes.
My lord, here they basically prayed that one is to quash the execution proceedings, and they also, my lord, say in this petition that they had raised the issue of maintainability and that has not been considered by the learned trial judge. Therefore, my lord, here in this notice has not been issued to me, my lord. I was unrepresented. I was unaware of this order. Then subsequently, my lord, all that, my lord, the learned single judge is not no prejudice caused to me, but all the learned single judge has done, my lord, is that has directed the trial court to consider the issue of maintainability and pass an order. It is pursuant to the direction in this judgment, my lord, that maintainability was heard by the learned trial judge, considering the fact, my lord, that in the earlier round of litigations, they have challenged the issue of maintainability as well as
So
limitation.
just Dinesh Kumar and just Krishna Dixit's order.
Please.
Saying that it is maintainable.
It's maintainable. In light of that, my lord, the learned trial judge says it's maintainable and has rejected the contention of the petitioner.
Now, in this writ petition, have you stated about all these in the narration of events that what had taken place earlier?
I'm sorry, I have not received a copy.
I'm asking you.
Well, actually, in the facts and circumstances, my lord, true facts have been suppressed by the respondent. My lord, 5/6/1990, we will also kindly turn to the synopsis. My lord. My synopsis, my lord. In the writ petition, my lord, synopsis, you will also kindly turn to synopsis. 15/6/1990.
In the synopsis, where did you say about the writ petitions filed by you?
My lord, you will also kindly turn to synopsis, my lord.
I'm looking at the synopsis.
Please, 15/6/1980. The
15/6?
father of the petitioners, my lord, K.C. stood guaranteed to the loan borrowed by the Armukam and Company from Indian Bank, also then depositing the title, including the scheduled property, that is all the piece and parcel of property. 2/11/95, my lord, the respondents, my lord, entered into, that is, well, also current to the cash title, my lord.
No, before going into that, according to you, why the
Now, because, my lord,
why the execution is not maintainable?
That's what I am telling you. Because, my lord, you will actually current to cash title, my lord. Indian Bank. Next page, my lord, M.R. Rajat, son of late M. Ramchandra. My lord, when the matter was disputed before the deputy court, my lord, he entered into agreement to purchase the property worth rupees 10 crore for rupees 2 lakhs.
List this matter as the first case tomorrow. Call the
Monday, my lord.
Monday as the first case.
May I receive a copy of the writ petition?
Copy of the writ petition to be
Please.
served and call the 230 matters.
Please.
Grateful.
230 mentioned matters. Cell number 34.
Keep this in that file. Yes.
My lord,
34.
for the direction of dishonorable court, my lord, on previous occasion there was a direction to file.
Please use the mic.
On previous occasion, there was a direction to file the memo of calculation to both the sides, my lord. I have filed memo of calculation and as well as the comparative memo of calculation also, my lords.
Where is the memo of calculation?
Lord,
Look at it. Could have. Where is
1/7. On 1/7/2026, I have filed the memo of calculation. On 6/7, I have filed the comparative statement of memo of calculation.
Have you served on them?
Yes, ma'am.
You have a copy?
I have served.
You have a copy?
Yes, ma'am.
Give it to the court of.
First one, first.
Two memos you have filed.
Minutes?
Two memos you have filed.
Yes, ma'am. One
where
is
is
the
the other
memo
one?
of calculation. After my friend served a copy,
This is the latest one.
once 6/7.
So let's see.
That is the comparative memo of statement, Millars.
Yes.
Wherein, Millars, there was a direction, Millard, the order of the arbitrator was challenged before the Honorable District Court, Millars.
This matter tomorrow.
Millard,
Tomorrow on the top of the list. It takes some time. Yes, next.
Number
Oblai.
And you have to represent in the morning itself. No pass out tomorrow.
Millard, I was held up in Kotal 2 minutes. Sorry, Millard, I apologize.
cell number 80. Cell number 80.
Lord, this is connected with serial number 92 and 93. The three matters, my lord, arise out of a common order. The factual background, my lord, plaintiff's writ
You can
petition.
straight away come to the order.
My lord, the impugned order is at running page 25.
Yes.
My lord, where the application filed for bringing the legal representatives of the first defendant was rejected without any reasoning. I will read the order at running page 25. He says 4, 5 and 8 was already passed. Lord, 4, 5 and 8, my lord, there were two sets of applications were filed. Earlier, my lord,
This is the reasoning.
sorry, my lord,
This is the reasoning given by the court.
that is all the reasoning. Lord, first defendant who was a spinster.
What about the other application? This is with regard to this.
My lord, that earlier, that order, my lord, is at running page 82, my lord, is the operative portion. Your lordship will look at running page 82.
What is this IA?
Look, there were two sets of IAs filed for bringing the LRs of the first defendant on record. She was a spinster. So the first set of IA, my lord, I made the siblings of the first defendant.
All these writ petition, all three shall be tagged. Then counsel the petitioner submits that when an application is filed to bring the LR so that this is a defendant on record. The court, without assigning any reasons, has dismissed the same. This court has perused the order. No reasons are given. Considering the submission, they shall be stay of all further proceedings.
Further proceedings in OS.
Pursuant to the order date so and so notice and summons, give a date. Yes, next.
8. Cell number 135.
Unless the petition is
Abhishek.
the petition is filed seeking to direct the Honorable Additional Civil Judge Mangalore, my lords, to allow the application under 151 filed by the petitioners, which are the defendants in the OS, my lords, seeking enlargement of time to file objections to the interlocutory application under Order 39, Rule 1 and 2 for temporary injunction. I was served. The suit is in
Where is the order?
Annex A, page 19. Sorry, page 23.
When was this IA filed?
It was filed on 5/8/2026 itself. On that day. Now, the suit summons was served to me on 12th of June, whereas on 5th of August, 10th of July, I appeared for the first time, and I filed section 148 application for written statement and 151 accordingly. That was allowed. Now the next date itself on 5/8/2026, I was not served the copies of the documents, which disabled me to file the written statement on the objection for the temporary injunction. And now on that day itself, on that 5/8/2026, along with 151 section 148 application was also filed, that was allowed,
Then
written
comes for the
statement.
petitioner submits that. The court, without giving any opportunity to the petitioner to file his objection, has rejected the request to file the objections, and objections to item number 2 is taken as read. And it is stated that the matter is coming up on 14/8/2026, and the court will proceed without the objections.
It's posted for orders.
And it's same, considering the same, there shall be stay of all further proceeding. Motion to the order date to same hand summons. Yes.
That's 2 weeks time.
Accepted. Yes, next.
Cell number 143.
Great.
143. Vandana PL for petitioner. Farah Kazi.
Why? There was no detailed order, and my lord, only the docket order was there. Your lordship, my lord, please to call for a report on the administrative side.
He said that there is some mistake.
Yes, now, yes. And my lord, in fact, my lord has also broad-heartedly agreed, my lord, that.
Last time it has come up before.
Yes,
the
it had
court.
come.
Then I said, whatever your, now the order copy is uploaded, you can question it.
I can question, your lordship, my lord, I am ready now. My lord, only 3 grounds, my lord. I have in fact, my lord, that
has to be there before the.
Your lordship may kindly have it tomorrow, my lord. We will just introduce, my lord, by way of an application, my lord, because I know urgency, my lord, it's being pleaded by them. Tomorrow or Monday, my lord, I will file a formal application so that, my lord, we don't end up filing one more petition.
My lords, that's true, my lords, but it's a 2005 matter, my lords. Short question, my lords. They have challenged after 26 years, that is Order 3, Rule 2, my lords.
Whatever is the order, that has to be on record, and I have
We
to
have
look at
the
it.
order.
He has to file it for.
I'll file
What
a
I do
simple
is,
application.
I'll take up this matter on Tuesday in the first list.
Please,
By
my
the
lord.
time, let them do whatever they want to do.
Please,
If they don't find, then I'll pass orders accordingly.
That may be recorded, my lords,
Let
because
council, let the senior council represent the council, the petitioner submits that. Now the order is uploaded by the court, and they're going, and they'll take necessary steps to question that order. And hence seeks time. Let's just matter on Tuesday. By the time, if the application, if the same is, if the order copy is not placed on record by filing appropriate application, the matter will be heard on the merits of the matter. Interim order earlier granted is extended.
it was no interim order extended, only we undertaking.
Let my learned friend continue the same courtesy, my lord. I have no issues.
Where is the earlier undertaking?
An undertaking.
Shall do, not interim order, if that gives you some happiness.
They have been very courteous, my
No,
lord.
my lords, we have to answer
Their
the clients also, my lord.
Earlier undertaking shall continue till Tuesday.
Greatly obliged.
Yes, next.
30 mood matter. Mahesh YL.
Yes.
Joint Commissioner of Bengaluru South City Corporation should pass a confirmation order by alleging that there is certain deviation in the building construction of my residential house.
Tomorrow morning.
But it just
Serve on the council.
But I have already served. She's
To whom you have served?
Copies received, my lords. I'll take notice for Likitar Prakash.
Yes. What about instructions?
My lords, so far as the based on the notice that is given by the BBMP, we have proceeded to disconnect the power connection.
When was the permission for your construction?
It was in the year 2023 itself. Right after the purchase.
Now the Supreme Court judgment will not apply to this.
My lord, so far as the appeal liberty that has been given to the petitioner, my lords.
The confirmation
In a writ
order
petition.
I had challenged
No,
before
but
the.
you have disconnected the power supply, it seems.
Yes,
Manoj.
Manoj.
But that
Based
is
on
personal.
based on an intimation by BBMP Manoj.
That's what I'm saying, that you cannot do. You
No,
restore the
Manoj.
power supply. You restore the
So,
power
Lordship.
supply. It is.
But irrespective,
Please,
the matter
Manoj.
can be disposed of. I'll just tell your lordships why.
Land Council for the petitioner submits that the respondent Bescom, basing on a communication received from the BBMP, has disconnected the power supply. Land Council for the respondent also does not dispute the fact that so and so Mr. Likita Prakash takes notice on behalf of the respondents. On instructions, it is submitted that based on the communication from the BBMP, they have disconnected. Land Council for the petitioner submits that. What about any notices from Bescom to you?
They have noticed. They have given a notice.
They have given a notice and they've issued a reply is given to you?
Yes,
Given by
they
you?
have given a reply. Manoj, what happens is based on the confirmation and the eviction notice by the BBMP, they would do this. Manoj. The said confirmation and the eviction notice, I would challenge before the coordinate bench of this honorable court. What the coordinate bench says is, I will reserve you liberty of 8 weeks. Go and file an appeal before the chief commissioner.
8 weeks when it will end?
The date of the order is dated 31/7/2026. Manoj. It would expire by the end of September.
It is submitted that when the BBMP has issued an order of eviction that was questioned before this court by filing a writ petition. And in the writ petition, this court has granted 8 weeks time to question the appeal. In the meantime, the Bescom has disconnected the power supply. Considering the fact that as per the order passed by a coordinate bench of this court, still the 8 weeks time is not elapsed. The Bescom is directed to forthwith restore the power supply. Notice to the respondents.
Yes. I will furnish the memo. Can I request for a hand delivery?
Yes, hand delivery of the order.
That's based on a letter, intimation issued by BBMP dated 15/7/26 months.
15/7/26. When is the order by the coordinate bench?
31/7/2026.
31/7/2026. List this matter on 3rd of September. Done. Huh? Who? Yes.
Court fee. With
So,
regard to
number
the court
submission,
fee, Manoj, I have
Manoj.
already paid minutes. Hand deliver court.
So one submission, one humble submission, my lords. Serial number 98, my lords.
Seri.
Tomorrow.
Lordships kind.
But serial number 98, my lords, the matter was listed for
Lordships kindly, my lords.
serial number
65.
98, my lords.
138, sir.
Matter settled before the trial court.
Serial
Lordships
number
kindly,
98, my lords. Matter was listed on 2 occasions. They took
convenient-
Passover and matter did not reach. There was
I'm
specific
appealing for the petitioner.
observation
90,
yesterday.
any convenient date, I'm ready.
Tomorrow,
19th.
my lords. There is interim order in their favor, my lords, from February.
Tomorrow not.
Please, my lords.
My serial number 65, my lord.
The lordship's time
Serial
permission.
number 76, my lords.
Madam, serial number
98,
67, may I
madam.
request for tomorrow?
98.
The trial court date is tomorrow.
What are that?
Serial number
98,
67.
number wise tomorrow.
Tomorrow ಬೇಡ. Tomorrow ಬೇಡ ಅಂತಿದ್ದೆ. ನಾನು ಬೇಡ. ಇಲ್ಲ ಇಲ್ಲ. ನಾಳೆ
ನಾಳೆ.
Serial number 67.
ನಾಳೆ ಹೇಳಿಲ್ಲ ಜಡ್ಜಿ.
ಹೇಳಿದ್ರಲ್ವಾ ನಾಳೆ ಮಂಡೇ
Court officer. Court officer. Court officer. Madam, number 111, what is the next date? Court officer, your mic is muted. Can you please unmute it? Excuse me, sir. Court officer, ಏನು ಕೇಳಿಸ್ತಿಲ್ಲ.
Court officer, your mic is muted. Can you unmute, please? Court officer.
Court officer, at what did the court ended? Which item did the court end? Court officer. Court officer, you are muted.
Madam, please respond.
ಹೇಳಿ ಸರ್.
Which
Madam,
item
serial
did
number
the court ended?
ಓರಲ್ಲ ಅಯ್ಯೋ ಇಲ್ಲ.
ಇಲ್ಲ ಮೇಡಮ್, ಅದಕ್ಕೆ 24.
Madam, what item did the court ended?
7 ಅಯ್ಯೋ ಇಲ್ವಾ? ಅದು 24/8 ಕೊಟ್ಟಿದ್ದೀನಿ ಇವ್ರೆ ಆಲ್ರೆಡಿ. ಹೇಳಿ ಸರ್. ಹೇಳಿ.
ಮೇಡಮ್
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 74 ಮೇಡಮ್ ದಯಮಾಡಿ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. 74.
Sir, all list 1 matters will be assigned date from Monday, Tuesday and Wednesday. I will distribute to 3 days.
Thank you madam.
ಮೇಡಮ್ ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 30 ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದೀರಿ? ಮೇಡಮ್ ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 30.
ಮೇಡಮ್
27/8 ಮೇಡಮ್.
ಮೇಡಮ್
Court officer.
Thank you, madam.
List 2 serial number 19.
ಅಯ್ಯೋ ಇದೆ ಮೇಡಮ್. ಇದೆಯಾ? ಅಯ್ಯೋ ಇದೆ ಅಲ್ಲ? ಮೇಡಮ್
Court officer. List 2 serial number 19 please.
99 sir.
Okay, thank
ಮೇಡಮ್
you.
ಲಿಸ್ಟ್ 2
ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ 1 ಅಲ್ಲಿ ಹಾಕಬಹುದಾ?
24th ಮ್ಯಾಟರ್.
ಮೇಡಮ್ ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 30 ಆನ್ ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ 1 ಅಲ್ಲಿ ಹಾಕಬಹುದಾ ಮೇಡಮ್? ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅದರಲ್ಲಿ.
Madam, list 1 item number 111.
ಮಾಡ್ರಿ ಇದೆ ಅಲ್ಲ? 7 ನಿಮ್ದು.
ಮೇಡಮ್ ಲಿಸ್ಟ್ 2 ಹಂಗೆ 20
List 1 item 111.
ಮೂವ್ ಮಾಡಿದ್ದೀರಾ ನೀವು ಸೆಟ್ಲ್ಮೆಂಟ್ ಗೆ? ಸೆಟ್ಲ್ಮೆಂಟ್ ಗೆ ನೀವು ಒಂದು ಮೆಮೊ ತಗೊಂಡು ಬನ್ನಿ, ಡಿಸ್ಪೋಸ್ ಆಗ್ಬಿಡುತ್ತೆ, ಲಿಸ್ಟ್ ಇಂದ ಹೋಗುತ್ತಲ್ಲ ಅದು.
ಮೇಡಮ್ ಲಿಸ್ಟ್
24/8 ಹಾಕಿರ್ತೀನಿ, ಅವತ್ತು ಬಂದು ಮಾಡ್ಕೊಳ್ಳಿಪ್ಪ. ಮೇಡಮ್ ಲಿಸ್ಟ್ ಯಾವ್ದಪ್ಪ? 132 1 ನಿಮಿಷ.
Madam, list 1 item 111.
ಲಿಸ್ಟ್ 2 24th ಮ್ಯಾಟರ್ ಮೇಡಮ್.
ಲಿಸ್ಟ್
24th
ಹೇಳಿ ನಿಮ್ದೇನು? ನಿಮ್ದು ಲಿಸ್ಟ್ ಇಂದ ಬಿಟ್ಟೋಗಿದ್ ಮ್ಯಾಟ್ರ್ ಅವತ್ತು ಅಲ್ವಾ?
ಹೌದು ಮೇಡಮ್, 15 ದಿನದಿಂದ 34 ಇತ್ತು.
ಅದೇ ಮಂಡೇ
ಸೋಮವಾರ.
142 serial number 142.
ಮೇಡಮ್ ಲಿಸ್ಟ್ 2 24th ಮ್ಯಾಟರ್.
ಒನ್ 19/8 ಸರ್.
ಏನಾಯ್ತು ಮೇಡಮ್?
19/8 ಸೆಕೆಂಡ್ ಮ್ಯಾಟ್ರ್.
ಮೇಡಮ್ ಲಿಸ್ಟ್ 2 24th ಮ್ಯಾಟರ್.
ಹೇಳಿ.
ನನಗೆ ಇಷ್ಟ ದಿನದಿಂದ ಅದು ಲಿಸ್ಟ್
ಇದೆಯಾ ನೋಡು.
ಇಲ್ಲ
ಇದು ಲೈವ್ ಇದೆಯಲ್ರಿ?
ಇದೆ ನಂಗೆ.
ಮೇಡಮ್ ಲಿಸ್ಟ್ 1 ಐಟಮ್ 111.
ಅದು ಲಿಸ್ಟ್ 1 ಅಲ್ಲೇ ಲಿಸ್ಟ್ ಆಗ್ತಿತ್ತು, ಈ ಸತಿ ಮಾತ್ರ ಲಿಸ್ಟ್ 2 ಆಗಿದೆ.
ಆಯ್ತು, ಐಒ ಇದೆ ಇದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿ ನಮ್ ಕೋರ್ಟಲ್ಲೇ ಗ್ರಾಂಟ್ ಆಗಿರೋ ಐಒ ಅದು 89 89. ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಸೆಕೆಂಡ್
ಆಯ್ತು 89.
ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಸೆಕೆಂಡ್ ಮ್ಯಾಟ್ರು. ಲಿಸ್ಟ್ 2 ನಲ್ಲಿ ಸೆಕೆಂಡ್ ಮ್ಯಾಟ್ರು ಏನ್ ಬೇಕು ಹೇಳಿ?
ಮೇಡಮ್ ಅದು 5 ಡೇಟ್ ಇಂದ ಬರ್ತಾನೆ ಇದೆ.
ಇವ್ರೆ ಅದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಂತಲ್ಲ ದೇವೇಂದ್ರ ಎನ್. ಹೌದು. ಅದು ಎಂಟ್ರಿ ಮಾಡಿದೆ, ಅದು ಡೇಟ್ ಹೋಗುತ್ತೆ. ಒಂದ್ ನಿಮಿಷ ಆಯ್ತು
ಮೇಡಮ್ ಅದು ಲಿಸ್ಟ್ 1 ಗೆ ಹಾಕೊಳ್ಳಿ. ಎಷ್ಟು ದಿನ ಲಿಸ್ಟ್ 1 ಇತ್ತು ಅದು? ಲಿಸ್ಟ್ 1 ಇತ್ತು ನಮ್ದು.
ಯಾವ್ದಪ್ಪ?
ಲಿಸ್ಟ್ 2 24 ಅಯ್ಯೋ ಇದೆ ಅಂತಂದ್ರಲ್ಲ. ಲಿಸ್ಟ್ 2
ಹಂಗೆಲ್ಲ ನಾವು ಲಿಸ್ಟ್ ನ ಆಲ್ಟರ್ ಮಾಡಕ್ ಬರಲ್ಲ. ನೀವು ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಬಂದಾಗ ಬಂದು ಸಬ್ಮಿಷನ್ ಮಾಡಿ. ಲಿಸ್ಟ್ 1 2 ಲಿಸ್ಟ್ 2 ನಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಅಲ್ಲ ಐಒ ಇದೆ. ಅದು ಸೆಪ್ಟೆಂಬರ್ 10 9 ಇವ್ರೆ
ಮ್ಯಾಮ್ ಅಷ್ಟು 5 ಡೇಟ್ ಇಂದ ಬರ್ತಾನೆ ಇದೆ ಅದು ರೀಚ್.
ಇದ್ರೆ ನಿಮ್ಗೆ ಹೇಳೋದ್ ಅರ್ಥ ಆಗುತ್ತಾ? ಪ್ರತಿದಿನ 70 ಮ್ಯಾಟ್ರ್ ಇದೆ. ನಿಮ್ಗೆ ಅರ್ಜೆನ್ಸಿ ಇದ್ದಾಗ ಲಿಸ್ಟ್ ಆದಾಗ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಕೋಬೇಕು. ನೀವು ಅದನ್ನು ಮಾಡ್ಕೊಳ್ಳಲ್ಲ. ಹೇಳಿ ಲಿಸ್ಟ್ 1 107 107 ಅಂದ್ರೆ ಟ್ಯೂಸ್ಡೇ ಬರುತ್ತೆ ಅನ್ಸುತ್ತಲ್ಲ. ಟ್ಯೂಸ್ಡೇ 88 ಇವ್ರೆ 88
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 46 ಸೀರಿಯಲ್ ನಂಬರ್ 1436
ನೋಡಮ್ಮ ಅದು ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ 14. ಅದೇ ತಗೊಂಡಿದ್ದಾರೆ ಇವ್ರೆ 98 ಗೆ ಹೇಳಿ.
36 ಮೇಡಮ್.
ಯಾವ್ದು ಸರ್? ಯಾವ್ದು? ಅದೇ ನಾಳೆಗೆ ಲಿಸ್ಟ್ ಆದ್ರೆ ನೀವು ಆನ್ಸರ್ ಮಾಡ್ಬೇಕು. ಆಮೇಲೆ ಹೇಳಿದ್ರೆ 94 ನಾಳೆಗೆ ಇದೆಯಾ? 94 ಎಷ್ಟು ಜನ ಸಬ್ಮಿಟ್ ಮಾಡ್ತೀರಾ? ನಾಳೆಗೆ ನಾನು ಆಲ್ರೆಡಿ ಕೊಟ್ಟಾಗಿದೆ. ಇವ್ರೆ ಮಂಡೇಗೆ ತಗೊಂಡಾಯ್ತಲ್ಲ ಯಾರು? ನಾಳೆಗೆ ಇವ್ರೆ ಕೊಟ್ಟಾಗಿದೆ.
36 ಮೇಡಮ್ ಸೀರಿಯಲ್
120 125 ಎಲ್ಲ ಫೋನಲ್ಲೆಲ್ಲ ರಿಸೀವ್ ಮಾಡಬೇಡಿ. 125 ಇದರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ ಇವ್ರೆ? ಟ್ಯೂಸ್ಡೇ 88
ಲಿಸ್ಟ್ 36 ಮೇಡಮ್ ಸೀರಿಯಲ್.
Madam 111, what is the next date?
21st ಬೇಕಂತ ಯಾಕೆ?
Madam 111.
36 ಸೀರಿಯಲ್.
ಇದ್ರೆ ನಿಮಗೆ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಲ್ಲ ಲಿಸ್ಟ್ 1 ಡಿಸ್ಟ್ರಿಬ್ಯೂಟ್ ಆಗುತ್ತೆ. ಡೇಟ್ ನೋಡ್ಕೊಳ್ಳಿ.
ಲಿಸ್ಟ್
ನಾನು ಅಪ್ಡೇಟ್ ಮಾಡಿ ಬೋರ್ಡ್ ಲಿಸ್ಟ್ ಕೊಡೋದು ಇವಾಗ ನಿಮ್ದೆ ಇಲ್ಲ. ಐ ವಿಲ್ ಡಿಸ್ಟ್ರಿಬ್ಯೂಟ್ ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಅಂಡ್ ವೆಡ್ನೆಸ್ಡೇ 3 ದಿನದಲ್ಲಿ ಡಿಸ್ಟ್ರಿಬ್ಯೂಟ್ ಆಗುತ್ತೆ.
ಮೇಡಮ್ 76 ಒಂದು ಮಂಡೇಗೆ ಹಾಕೊಳ್ಳಿ ಮೇಡಮ್, ಅರ್ಜೆಂಟ್ ಇದೆ. 76 ಲಿಸ್ಟ್ ನಿನ್ನೆಯಿಂದ ಇವತ್ತಿಗೆ ಹಾಕೊಂಡಿದ್ರು.
Madam, what about 111, ma'am? 111.
Sir, all list 1 matters will be distributed Monday, Tuesday and Wednesday.
Okay, thank you, ma'am. 111 also, ma'am?
All matters.
Thank you, ma'am. 111